All right, if folks could take their seats, we're going to get started here. Thanks everybody for coming out today. Good afternoon. Thank you for joining us for this important discussion about defending liberty, challenges and solutions for protecting the right to counsel in Texas. I am Scott Ehlers. I am the Executive Director at the Texas Indigent Defense Commission. TIDC protects liberty and families by ensuring that Texas and its 254 counties provide counsel as guaranteed by the U.S. and Texas constitutions and Texas statutes. TIDC funds, oversees, and improves representation in adult criminal matters, juvenile delinquency cases, and family protection representation, which is provided in child protective services cases. I'm joined today by many of TIDC staff who are in the Army Green Public Defense shirts, who I want to thank all of you for helping out so much. We could not have done this without you, so thank you, thank you, thank you. First off, I would like to welcome Representative John Smithy. He is the chairman of the House Criminal Jurisprudence Committee and the newest member of the Texas Indigent Defense Commission Board. Chairman Smithy.
Thank you. I'm glad to be here today. And so for about the last month, I've been chair of the Criminal Jurisprudence Committee in the Texas House, which is a real honor for me, and it's a big challenge, I think, for me and for our entire committee. We had our second meeting today, and we completed it just a few moments ago. And as Scott said, one of the chair of that committee is a member of the commission, Indigent Defense Commission, and so I look forward to working on this issue. There's no more fundamental component of our criminal justice system than to make sure that every defendant who is before the criminal justice system has access to competent counsel and motivated counsel to get a fair trial and to make sure that his or her rights are protected. So that's something that I'm committed to, and I look forward to having the opportunity to work on the issues related to that very important right with the commission and in the legislature as well. So we look forward to working with all of you on that. Thank you very much.
All right. Unfortunately, Senator Zaffirini could not join us today due to multiple conflicts. So we wanted to play a prepared remarks from our chair, Judge Missy Mederi, out of Nueces County.
Good afternoon, everyone. Welcome, and thank you for being here. And thanks especially to Senator Zaffirini for sponsoring this event so we could use this wonderful facility. My name is Missy Mederi, and I have the privilege of serving as chair of the Texas Indigent Defense Commission. Thanks to Governor Abbott, I have been on the commission for almost 10 years now. I am also the elected 347th District Court Judge in Nueces County, Texas, and the regional presiding judge for the 5th Administrative Judicial Region. Today, Texas faces a crisis in indigent criminal defense and family protection representation, particularly in rural areas. This shortage of attorneys is the biggest indigent defense challenge Texas is facing. The demand for appointed counsel continues to grow, yet too few attorneys are available to meet the need. Courts must rely on attorneys from hours away, leading to delayed justice, higher costs, high attorney caseloads, and lower quality representation. Findings from a recent report from Texas A&M's Public Policy Research Institute, or PPRI, highlight the severity of this issue. PPRI found that since 2014, rural Texas lost over a quarter of their indigent defense lawyers. or over 500 attorneys. Indigent defense lawyers are getting older and nearing retirement, which means the crisis will only get worse in the coming years unless we act now. Today you will hear about potential solutions to this crisis. First among them is increased state funding. Criminal defense in Texas is primarily funded at the county level. Counties cover about 90% of the cost, but counties are struggling to keep up. And when it comes to appointing and paying attorneys in CPS cases, the counties are entirely on their own right now. County property tax bases and budgets vary wildly across the state, resulting in poorer communities and counties having much less money to provide constitutionally and statutorily required legal representation. Increased state funding is needed to ensure equal access to legal representation across Texas. TIDC is seeking $47.5 million this biennium to help cover the cost of family protection representation in CPS cases, with the goal of increasing quality and bringing more attorneys into the work. TIDC is also seeking millions in part to establish more rural regional defense public defenders offices, which can draw attorneys into indigent defense work with a salary, benefits, training, and mentorship. TIDC has another funding request to establish paid internships, fellowships, and a student loan repayment program to draw more attorneys to rural Texas and other high-need areas. Public defender offices offer many benefits to participating counties and courts, including helping to solve attorney availability issues, improving the quality of defense, and improving court efficiency. Rural regional programs offer additional value by allowing counties to pool their resources, jointly access state grant funds, and more importantly, assure rural counties have good attorneys who show up to court on time to provide quality representation for the defendants who require appointed counsel. The PPRI study showed stakeholders from counties with public defenders' offices are happy with their offices. As more county leaders see the benefits of the programs, demands for additional offices continues to climb. TIDC needs the resources to continue to help counties establish more public defenders' officers, as we recently did in Nueces County. I hope you enjoy your program today and you gain new perspectives from our wonderful panelists as they share their stories of indigent defense, challenges they faced, and the solutions they've put in place. Thank you for your time and your interest in protecting the right to counsel in the great state of Texas. Please reach out to TIDC if you have any comments or questions, and have a great day. Thank you.
Thank you, Judge Mederi. So we're gathered here for a few reasons, and one is in part a celebration. It's a celebration of the 62nd anniversary of the unanimous Supreme Court decision Gideon versus Wainwright. The anniversary is next Tuesday on March 18th. Gideon was Clarence Earl Gideon. He was arrested for the felony of burglarizing a pool hall in Bay Harbor, Florida, where a cigarette machine and a jukebox were robbed. Mr. Gideon asked the state court to appoint a lawyer to assist him at trial, but because he didn't have any money, and the judge refused because Florida state law and U.S. constitutional law at that time in 1961 only required an attorney be appointed in death penalty cases, not a little old felony like Mr. Gideon was arrested for. Gideon tried representing himself before a jury, but he was convicted and sentenced to 5 years in prison after sitting in jail pre-trial, had no means of investigating his own case, and he had no knowledge of how to conduct a trial. Mr. Gideon did figure out, however, how to get his case to the U.S. Supreme Court, and he submitted a petition in pencil written on the paper given to him at the prison. The court accepted his case and appointed Abe Fortas a lawyer with the prestigious DC law firm Arnold, Porter and Fortis, to represent Mr. Gideon. The Supreme Court would unanimously rule in Gideon's favor and establish that felony defendants in state court were entitled to the appointment of counsel under the 6th Amendment and the 14th Amendment's Due Process Clause. Sorry, I missed, this was his petition that Mr. Gideon wrote. As Justice Hugo Black would write in the majority opinion, that government hires lawyers to prosecute, and defendants who have the money to hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. One of those Supreme Court justices to unanimously join Justice Black was Texan Tom C. Clark, who wrote a concurring opinion to emphasize that the 14th Amendment requires due process of law for the deprival of liberty just as it does for the deprival of life. Clarence Earl Gideon would go on to have his case retried in Florida, this time with an attorney by his side, but this time he would be found not guilty. He would also be welcomed back to the Bay Harbor pool room. Mr. Fortis would go on to become a Supreme Court justice. How the Gideon decision was implemented was left to the states. Texas, like many other states at the time, delegated its duty to the counties to protect defendants' right to counsel. As you can imagine, with 254 counties having widely varying degrees of financial resources and even more judges deciding which defendant was entitled to a lawyer, whether a defendant actually got a lawyer and the quality of that lawyer differed wildly from county to county. Things have gotten better since the passage of the Fair Defense Act in 2001, when the Task Force on Indigent Defense, and later named the Texas Indigent Defense Commission, was established. The state started providing funding for the first time, but even today, the counties continue to pay for about 90% of the financial support for indigent defense. Appointment rates, especially for misdemeanors, vary greatly across the state, especially there are single digits in some counties, and in other counties, the vast majority of defendants will get a lawyer in a misdemeanor case. In addition to celebrating the Gideon decision, the other reason we've brought you here today is to discuss the #1 challenge to protecting the right to counsel in Texas. And that includes the right to counsel in criminal cases, in juvenile cases, in family protection representation cases, or representing children and parents in child protective services cases. That #1 challenge that we are facing in protecting the right to counsel is the attorney shortage crisis for all of these cases, particularly in rural Texas. In your materials, we provided a copy of a great article that was published in the Texas Tribune a couple of weeks ago that describes these challenges that Texas is facing today. We put together some great panels where we're going to discuss the rural attorney shortage crisis and other challenges Texas is facing, but we're also going to be talking about solutions that TIDC and the counties have put in place and are proposing this legislative session. Before we do get to the panels, I wanted to discuss TIDC's legislative appropriations request, our exceptional items, and the legislative proposals that are included in an omnibus bill, SB 2111, that's SB 2111, that was introduced yesterday by Senator Zaffirini. So for those of you who are not familiar with TIDC and our work, we fund over indigent defense in Texas. Once again, that's in criminal matters as well as family protection representation. In terms of the funding, we have a couple of different types of grant funds. We have formula grants all counties get. We have improvement grants to help improve the system, build public defender offices, manage assigned counsel programs. We also have an oversight component where we do fiscal audits of the counties to make sure that they're using their funds appropriately. And we also do legal audits or policy monitoring of the counties to make sure that they are following the law, appointing counsel properly and in a timely manner. And then we also have an improvement team that develops planning studies for counties for those public defender offices to help build them, let them know what kind of costs are involved, what kind of grants we can bring to the table. We also provide technical assistance, trainings, etc. Did want to note the legislation that passed last session, SB 2120. That is what directed TIDC to start working on family protection representation issues. Unfortunately, the legislature did not appropriate any funds for that work, and we're going to be talking a bit more about that when I talk about the exceptional items. So these are the biggest issues that we're facing, TIDC and the state are facing right now, and we've incorporated all of these into our exceptional item requests as part of our legislative appropriations requests. So the first issue that we're facing is a significant shortfall in the fair defense account, which is our general revenue dedicated account, and we need more reliable sources of revenue for that. Right now, pretty much the vast majority of those revenues are from court costs, whether it come just in a general manner to us for every criminal conviction, as well as a fund called the Juror Service Fund, which is part of the consolidated court costs, and which TIDC historically received about $6 million per year. Those funds have dried up, and we're no longer receiving anything from the Juror Service Fund. We're also, as I've mentioned before, facing an attorney shortage crisis, particularly in rural Texas. As I also mentioned, the legislature directed us to work on family protection representation matters, but they have not appropriated any funds to do that work. And TIDC also has staffing needs for our family protection representation program and our recruiting efforts. So this is our first exceptional item. We requested $12 million, and then we amended that to collect $7.7 million in GRD to address our shortfall. The $7.7 million that we amended our request comes from the fact that the Office of Capital and Forensic Writs used to receive funding from our general revenue dedicated account, and this session the legislature has moved their funding to general revenue instead, freeing up $7.7 million, and so we requested that amount as well. Here you'll see TIDC has received, our appropriation is $10 million less this biennium than last session, and that is, like I said, due to the revenue shortfalls that we are seeing in the fair defense account. And just today we learned that the House subcommittee on Articles 1, 4, and 5 approved $10 million in GR that's general revenue, to fill TIDC's revenue shortfall. So they've basically decided to address this shortfall with $10 million in general revenue. Tomorrow we'll be hearing from the Senate Finance Committee and learn what the Article 145 work group decided for us in the Senate. But thus far, the House Appropriations Subcommittee has decided to give us $10 million in general revenue to address that shortfall. This is just a historical look at our shortfalls across the years. As you can see, we're about $10 million down every year compared to historical highs. If you added all that money together, we're down about $54.7 million between FY19 and 24 for general revenue dedicated. Our second exceptional item is seeking to address the attorney shortage crisis by establishing what we call a pipeline program at the Indigent Defense Commission, which would have internships, fellowships, and a student loan repayment program. As you can see here, the percentage of felony cases that require appointed counsel has been going up over time, particularly in rural areas. And as was mentioned earlier, recent research that we did at the request of the legislature that the Texas A&M Public Policy Research Institute did for us found that the attorneys in rural Texas are down about 27%, or about 500 attorneys between 2014 and 2022. What does that mean? Well, one of the things that it means is that the remaining lawyers that are out there handling cases are more and more overburdened. And so this is a heat map of sorts that will show you where there is more overloaded lawyers across the state. And as you can see, from 2014 to 2022, you have a lot more counties with darker red coloring, which means that 20% or more of the lawyers in that county have a caseload that exceeds TIDC's caseload guidelines. So what we're proposing for exceptional item 2 is, through our pipeline program, is to have an internship program that would fund up to 96 law students that would be about 2 interns for the 30 offices per year in the state. The rural fellowship program is designed to address that gap in practice from when someone is a law student, they get licensed, or they're waiting for licensure while they've taken the bar. And so a lot of offices could use a fellowship program to help fund that gap program. In terms of the internships, we found that if we can get law students out to rural Texas, see what a joy it is to work out there, that many of them will choose to stay there after that exposure. And then finally, there's a rural loan repayment program here, or a loan repayment program for high needs areas. Doesn't necessarily have to be rural, but we know that's a high need area. And we're looking for $5 million for the biennium to pay for that program, and that would be based on, it's really based on a program that is for physicians right now that is bringing physicians out to rural Texas. We'd like to do the same thing for attorneys. So for exceptional item 3, I'm going to bring Crystal Leff-Pignon, our Director of Family Protection Representation, to talk about that.
So I'm here to talk about our exceptional item number 3. To give you a really brief background, we'll talk a little bit more later in the program about family protection representation. But when we say family protection representation, what we mean is legal representation for parents and children who are involved in child protective services cases. So those are those civil suits that are brought by the Department of Family and Protective Services, making allegations against parents and potentially separating children and parents and that sort of thing. Our ask for the biennium is $47.5 million. Our logic was based on some data collection that we've been doing. So back in 2021, TIDC began collecting data on behalf of the Texas Judicial Council. There was a bill filed back during the '86 legislature called SB 560 that started a requirement that counties submit data for the first time. Prior to 2021, we actually really didn't know how much was being spent. So this data collection has been very important in understanding what's happening out there a lot better. And so we do have a good understanding now of generally what counties are spending to provide this representation to families. This representation is statutorily required in the Family Code, and right now, as Scott said, counties are completely 100% footing the bill for this. So what we see from our data collection is the spending is between $60 and $66 million a year. It changes every year depending on case filings and the types of cases that are involved. The 3-year annual average that we've seen is $63.5 million. We do have data for 2024. We're going through it right now. So right now, these are the numbers we have that are fully confirmed for what counties have reported spending. For the last biennium, the 2022-23 biennium, the total spending was $124.3 million over there that you see over there. So where did we come up with that $47.5 million number? It's like, what is this, like totally arbitrary? It is not arbitrary. We had some logic with this. So there is an organization called Texas CASA. Some of you might be familiar. For those of you that are not, Texas CASA provides something called a guardian ad litem to children. Guardian ad litems are not attorneys. They are appointed to represent what's called the best interest of the child, and they can substitute judgment, but they can't do any lawyer things. They can't file motions, they can't make arguments in trial, they can't call witnesses, and they are generally volunteers. So when you hear about those court-appointed special advocates, they do a lot of work in the community trying to get volunteers. Those are volunteers that are providing those services. Texas CASA is an overarching organization over the state, and then they have different county organizations. Texas CASA gets 37% of their budget. Generally, it's around 37, that's kind of the general number. But 37% of their budget comes from state funds. And last year, they got around $16 million from the state to support their work. So when we were looking at how much to ask from the legislature, our board voted to support this request and just ask for that same level of parity with Texas CASA, even though what we're asking for are lawyers for kids and parents doing all of this lawyer work. We thought it would be a fair start to just ask for that same percentage of that 37%. So that's where the 47.5, well, actually it's 46.4 when we look at the spending, and then we added some extra for 5 FTEs to come out with the 47.5 million. Right now, our division at TIDC is, we are tiny but mighty. It is myself and a half of another FTE that we are working to try and improve this system. To really, truly make some true difference, we do need some more FTEs. So we've asked for 5 FTEs. One of them is a staffer to work full-time on Title IV-E funding. We have made huge progress in that space. We actually have a negotiated MOU with the Department of Family and Protective Services for TIDC to provide supportive services and to work on improving this reimbursement. So Title IV-E, for those that are not aware, is a federal reimbursement program. So if a county spends funds to pay for lawyers for children and parents, they are supposed to get a percentage of that money back from the federal government. And right now, Texas is grossly underutilizing these funds. At any point, it's give or take about 20 counties that are accessing their money. We have 254. And this money has been available now for about 5 years. And we're just literally leaving millions of dollars on the table. And part of the reason why that's happening is because DFPS has 1,000,001 things to worry about. And this has not been something that they've had the bandwidth to create a robust program. So we have this wonderful MOU to have a partnership with the department to create a more streamlined and efficient program, but we really, really need a full-time staffer on that. I can't do that myself, so we really do need someone on it. And if we get that FTE, we will actually generate revenue. It will be a revenue-generating position, so that's really important. And we've also asked for other FTEs to do other work. Hopefully we'll get some money to get some grants out the door, and we need a fiscal analyst, and we need some policy analysts as well to really make this program work. All right.
Thank you, Crystal. Our fourth exceptional item is to really build on some of the great work we've been doing in rural Texas, building more rural regional public defender offices. We have a special funding stream or formula, let's say, or maybe I shouldn't say formula because that might confuse things with formula grants. So as part of our improvement grants, we have sustainability grants for rural regional public defenders where we will pay for 2/3 of the costs of a regional public defender over really in perpetuity as long as there are funds there. So as our regular funding model for improvement grants is we'll fund 80% of a program in year 1, and then it goes down to 60% in year 2, then to 40, then 20, and by year 5, the county will pay for it on its own. When it comes to rural regionals, which are 3 or more counties with 100,000 population or less, we've decided the only way that that program is viable is if we commit to the counties that we are going to fund those programs for long periods of time and basically make a permanent commitment as long as the legislature funds us to fund those programs. So we have expanded the number of public defender offices in Texas significantly over the last 5 years or so. When we've instituted this program, you'll see all these beautiful colors across the state, which represent, in many cases, a rural regional public defender office. So those yellow counties there is the Concho Valley Public Defender Office. Those blue counties, light blue up there in the panhandle, is the High Plains Regional Public Defender Office that's just getting off the ground. Red counties out in far west Texas, that's our far west Texas Regional Public Defender Office. You'll hear more about that later. So, you know, as we've gotten sustainability funding in place, more and more counties have come to us to say, hey, we would like a rural regional public defender office because it brings lawyers to those rural counties. As you can imagine, if you were coming straight out of law school and you had, I don't know, $150,000, $200,000 in debt, maybe you don't even know anybody out in rural Texas, you might figure that that's not a good bet in terms of making a living going out to rural Texas just and starting up your own private practice as a solo practitioner. That's a lot to ask of a new attorney coming out of law school. So what public defender offices do is they, provide a salary and benefits to those new lawyers. They provide the opportunity for federal loan forgiveness. They offer training and supervision and a way to really get settled, to know the community, as well as, know how to become a good lawyer. And so we found them to be successful in terms of attracting new lawyers to rural Texas. And this exceptional item 4 is seeking $35 million to do more of that. So how do we come up with that figure? Well, that Public Policy Research Institute research that we've mentioned a few times, as part of that, they made an estimate of how much it would cost to cover those counties that actually want a regional public defender office. We did a survey as part of that work and found that about a third of respondents in rural counties without a public defender office now said, yes, we would like one. The other third said, I don't know. The other third said, no, thanks, we don't want that. Hopefully, those last two categories will change their mind. But we know, we have a good sense that here and now, about a third of them would like an office, and that comes out to about 60 counties. And so they ran the numbers, really based their estimates on like how many cases that would represent. And so the cost that they came up with was about $23.5 million per year to operate those offices. And so over the biennium, we figure, okay, well, we'll need about half the year to start up the offices, the other half to, actually operate that half of those half of the offices, and then that second half of the biennium, we would start up the other half of that ask. So 30 would start up in the first biennium, first year, 30 in the second, and by the end of the biennium, we would have hopefully 60 counties, or at least that many in terms of caseloads to cover by the end of those 2 years. So beyond the $23.5 million, though, we're also asking for about $11.5 million for urban counties and mid-sized counties, because they were not included, as well as any counties that are rural and maybe too poor right now in terms of their property tax base to afford our current program, so we'd like to help them out too. So that is our it for our legislative appropriations request. TIDC also has a process where before every legislative session, we go through a legislative work group process where we get stakeholders together to tell us what kind of changes are needed in the indigent defense system to improve it. And so we go through the stakeholder process. We bring those recommendations to our board, and the board will approve those things which they like, and then bills are drafted, and then hopefully the legislature passes some of them. Most of our proposals this year that went through that process are in an omnibus bill that's being carried by Senator Zaffirini, SB 2111, that was filed yesterday. And we're looking for a House author right now. If you know anybody who might be interested, looking for a House author. So here are a few of the things that are in that omnibus. I'll note when something couldn't get in the omnibus for some reason. One of the things that's in the omnibus is we, like I said, would like additional revenues to help shore up the fair defense account. And the idea that we came up with was, well, what about alcohol taxes? There is a clear nexus between some indigent defense costs and alcohol, particularly drunken driving. And so we made an estimate of about $30 million every year in indigent defense costs is spent to defend misdemeanor DWIs and felony DWIs. And so we're seeking 1% of the mixed beverage taxes to go to the fair defense account, which funds TIDC and our operations. So that's in SB 2111, Section 16. And so, once again, if any of you are interested or work for someone who might be interested in this as a standalone item as well, let me know, because we can make that a standalone item too. The other thing that is in the omnibus is statutory implementation of our pipeline program. So statute needed to be tweaked a little bit for us to have clear authority to run an internship and fellowship program, as well as to allow the Texas Higher Ed Coordinating Board to run the loan repayment program. So that is in the omnibus as well, to create that statutory authority for both us and the Texas Higher Education Board. There's a number of provisions in the omnibus as well, dealing with Article 1517 of the Code of Criminal Procedure, or magistration. That's the point of in which it's the first judge that if someone is arrested, they go and see where your rights are read to you, where you're told you have the right to a lawyer, where they determine indigence, all of those things. So if you've ever looked at Article 1517, you know that it's kind of a mess. It's just one big, huge, long paragraph that could use a little help in terms of breaking it up into subsections. So we would like to do that, make it a little more easily readable. There's also some provisions in there that were changed a few sessions ago that could cause some problems in terms of proper preservations of magistration records that we would like to clean up as well. Also within this category, would be a provision to provide limited scope attorney appointments at magistration. This would just be clear authority to do so because there are some counties who are already doing this. Harris County, for example, Fort Bend County, Travis County is starting it up as well, where counsel is being provided at magistration, and this would just clearly allow for that. Another thing related to magistration that we're seeking to change is allowing for part-time public defenders with a part-time criminal practice to provide representation at the Article 1517 hearing. Right now, there is a prohibition on part-time public defenders who have a criminal practice on the side, and so we've seen some counties who don't have enough cases for a public defender, a full-time public defender, and so they've had to hire like family law lawyers and train them up on criminal matters, which doesn't make a whole lot of sense. So we'd like to change that as well. Manage assigned counsel programs. There's a number of provisions in the omnibus dealing with this. For those of you who are not aware of this concept, manage assigned counsel programs are basically kind of a hybrid between a public defender office where you've got this centralized office that is taking care of a lot of the jobs of the indigent defense provider, but all of the lawyers for a manage assigned counsel program continue to be private lawyers. So in a public defender office, they're employees of the office. In a managed assigned counsel program, the lawyers continue to be private, and the MAC will appoint those private attorneys to take the cases, but the MAC also does things like appoint counsel, pay counsel, provide social workers and investigators to those private lawyers. They provide mentorship and trainings to the private bar as well. And so there's a number of changes we'd like to make to the MAC statute to basically update it and modernize it. And we have here today Jim Bethke, who runs the Bexar County Managed Assigned Counsel Program. So Jim, if you'd like to raise your hand. If you have any questions about MACs, Jim would be happy to answer them, I'm sure. Jim also used to run the Indigent Defense Commission. Oh, I'm sorry. Katie Joe from the Capitol Area Private Defender Service is also here, runs the Travis County MAC. Sorry, Katie Joe, I didn't see you over there. So we've got two MAC folks here. If you'd like to learn more about this concept, which I'm personally a big fan of. Started my private practice working in Travis County under a MAC, so I think they do great work. And there's also a provision that's in a separate bill, SB 1848, dealing with MAC access to juvenile records. Right now, there are no MACs handling juvenile cases, but in Bexar County, they would like to do so soon. There's a variety of provisions related to public defender offices in the omnibus. Issues dealing with home address confidentiality for public defender and MAC employees. This was in a bill last session that almost made it across the finish line but did not. Public defender investigators would like to have access to driver's license photos in the DPS database as part of their work to make sure that they're, who they are looking for to talk to is actually that person, so updated photos in that DPS database they'd like access to. Right now, counties, if you have a public defender office and you're handling cases that are arising out of a prison crime, you could get those funds reimbursed if you had a private attorney doing the case, but not for public defender offices. So would like to fix that. And then right now, if you're at a public defender's office and you find out your client actually had the funds to pay for your services, you're supposed to tell the judge about that information, and clearly this could be a conflict and result in your own client being arrested, and so would like to remove that conflict from the law. A few other items in the omnibus that you should be aware of. There's a provision here for innocence writs. So it would require the court to appoint an attorney to investigate and file a writ of habeas corpus when the prosecutor says they may have a claim of relief from a prior conviction. Approving attorney-client visitation for out-of-county situations. Right now, there's many counties that are not paying their lawyers in order to take those out of county to go visit their clients out of county, so we'd like to improve that. There's also attorney shortages for death penalty cases, and so our board passed a provision to increase the number of lawyers taking death penalty cases, and we're still looking for a sponsor for that. And then finally, Crystal, would you like to come back and talk a bit about our fee schedule cleanup, which is in a separate bill from the omnibus?
Oh, I think I saw 5 minutes. Yeah, so we have a separate bill. It's SB 1838. This was filed, I think, last week by Senator Zaffarini. So I don't know that a lot of people in here practice child protection work, but for those of you who don't know, there is a law currently in the Family Code that references fee schedules for attorneys who take court appointments in child protection cases, but the law is extremely unclear. The way the law is currently written, it takes you from the Family Code over to another section of the code that's in the Juvenile Justice Code, and then it routes you over to the Code of Criminal Procedure, which is written specifically for attorneys who do criminal defense cases. So it's very unclear what the rules are supposed to be for fee schedules for attorneys in child protection cases. This bill would fix that issue. It's much needed. We need clarity and guidance for everyone involved in child protection cases and what the fee schedule should be. So it cleans that up. It creates a new section of the Family Code with specific rules for fee schedules for attorneys who take court appointments in CPS cases. And it also it amends a few other sections of the code to ensure that all of the cases where there are statutory rights to counsel are included. Right now, a lot of the laws only reference termination of parental rights or conservatorship cases. So conservatorship is when a child is in the custody of the government, when DFPS has taken the child from the parents legally. There are other cases, orders for required participation, that have rights to counsel in the Family Code. There's also a pilot project called the Family First Pilot Project that also has rights to counsel in it. And so the bill would also ensure that anywhere that there's references to rights to counsel, that it includes everything listed in the Family Code. And so it would clean those things up too. So it's mostly a cleanup bill, but this would be a huge improvement for attorneys who take these cases and the courts as well, so that the rules are clear.
So that is it for TIDC's omnibus bill. Once again, that's SB 2111, as well as the other bills that came out of TIDC's legislative work group process and through our board. Did anybody have any questions about any of those matters? Once again, if you work, oh, yes, sir, Mr. Bethke. We have a microphone coming your way.
Thanks. Good presentation, Scott. I am curious your thoughts on whether you think the legislature will appropriate more funding for indigent defense.
Well, as I mentioned, we've already got indications, at least on the House side, that they're willing to fill the hole that we have right now with an additional $10 million. And I don't know if I mentioned the fact that for exceptional item number 4, regarding those funds to build additional public defender offices, that the House Appropriations Subcommittee did approve of $17.5 million for that exceptional item 4. And so for those two items, at least the House Appropriations 145 Subcommittee has approved of some funds going forward. We originally thought we were going to get the full $47.5 million for family protection representation. Representative Wu was kind enough during the first House Appropriations Subcommittee meeting to work for that and ask for it to be included in our budget. Unfortunately, we heard today that it has been moved to what they call Article 11, which means it's, you know, kind of hanging out on the side, waiting to be resurrected and put back into the bill. And so family protection representation on the House side, at least, is in Article 11, as is funding for the pipeline program. Also hoping to get some money in the supplemental appropriations bill that would help fund the shortfall that we have, that we're living with here and now. We could not fund about $7 million worth of grants last year because of the shortfall, including, you'll hear later today about Wharton and Matagorda counties. We couldn't fund them. We wanted to expand into Val Verde and Terrell counties, and unfortunately couldn't fund them because of the shortfall. So hopefully we can get some funds into that will be in the supplemental bill as well, to kind of fill what we were lacking for this year. Any other questions? All right, well, on that note, why don't we call up our first panel. We're going to be talking about challenges and solutions for the attorney shortage crisis in criminal public defense. Let me ask this. We've got 10 minutes according to the schedule. Would y'all like a brief break and then come back? I'm getting some noddings of heads. Technically, according to the schedule, we're a little ahead. So we will start back up at 3 o'clock then. So hope to see you back. Thanks. Okay, welcome back, everybody. We are going to start our first panel discussion now. We're calling this Challenges and Solutions for the Attorney Shortage Crisis in Criminal Defense. Once again, I'm Scott Ehlers, Executive Director of the Texas Indigent Defense Commission. I'm going to be moderating this panel, and I'm just going to go from my left on down and let my panelists introduce themselves. So first off, we have Judge Roy B. Ferguson. Judge Ferguson, tell us a little something about yourself.
Thank you, Scott. So my name is Roy Ferguson. I am the former judge of the 394th Judicial District Court. You'll hear more about the layout and makeup of that court. We call it ultra-rural. Rural wasn't good enough for us, so we're ultra-rural. What that means is we have as many square miles as we have people, and we are 3 hours from the nearest Starbucks. So when we talk about rural, we mean rural. While I was out there, I served 3 terms. I was a general jurisdiction judge, which means I handled all the child welfare cases and those appointments, family law cases and related contempt appointments, and then the felony criminal docket and all of those appointments, which worked out to 500 minimum felony indictments a year across the district. My background related to indigent defense is that I am on the Children's Commission. I'm a commissioner on the Children's Commission, which oversees the child welfare system. I am a commissioner and an executive officer of the Access to Justice Commission, and that oversees indigent defense in civil cases. And then I am the chair of the Legal Desert and Rural Representation Committee of the Access to Justice Committee, entirely focused on the very nature of the topic here today. So that's what brings me here to you.
Great. Thank you, Judge Ferguson. Stephanie Brown.
I am Stephanie Brown. I'm the Chief Public Defender for the Atascosa Area Advocates Public Defender's Office. It's a mouthful, I know. We are located currently in Pleasanton, Texas. That's a recent move from the county seat of Jordanton, Texas in Atascosa. We currently represent clients in Atascosa, Frio, Karnes, and Wilson counties. We are 21 attorneys in our current office, and that means we are currently staffed to the max. And that is a very good thing.
That's awesome.
We have an investigator, 2 investigators, a social worker, and 3 office staff members, and I'm so proud to work with these people. I cannot do this job without them, and they know that each and every day because I tell them that. My background consists of being a prosecutor in Atascosa County after I got out of law school 3 years ago. I did prosecution in Bexar County. I did indigent defense work in Bexar County. And full circle, I am back in Atascosa County now as a public defender. It is my joy to be a public servant. It's in my blood. My family, they're all public servants. And so I was raised that way, and it's basically the only way I know how to do this. So thank you for having me here.
Thank you, Stephanie. Judge Spinrath.
Is my light?
Yes, sir.
I can't see my light. Well, thank you for having me today. My name is Philip Spinrath. I'm in my 4th term as a constitutional county judge in Wharton County. Our county seat is Wharton, Texas. We are located south of Harris County in Houston, approximately 60 miles. What's different from my situation is we're not ultra-rural, but Harris County has about 4.5 million people. You travel 30 miles, you run into Fort Bend County, which is right at 1 million people. You go another 30 miles, and we're sitting there with 42,000. And so it's a big jump from 4 million to 42,000. So one size doesn't fit all. We have 2 district courts. We share one of our district courts, the 23rd, with neighboring Matagorda County, and then the 329th sits solely within Wharton County. And then we have my constitutional county court. We do not have courts at law. We do not have statutory probate courts. I hear everything from criminal, civil, mental health, guardianships, probate, the whole gamut as far as that goes. I spend well over 75% of my time in judicial court. What makes me a little different than probably Judge Ferguson is a county judge. My position is probably more political. I also sit on a commissioner's court, and I will tell you my commissioners believe that we need more money for asphalt and less money for indigent defense attorneys. And the unique thing is I am the chief budget officer in our county, and I have to be cognizant of the taxpayers. The thing that will get me thrown out of office or voted out of office isn't going to be what I do in the court, where I spend 70+% of my time. It's going to be raising someone's taxes, or somebody doesn't get their road paved or their pothole filled, which I have nothing to do with. But as you may know, in Texas, county judges do not have to have a law license. I am licensed in Texas and in Michigan, where I attended law school, but that's only about 25% of the county judges. We had 2,072 cases last year in all of our courts, in our district courts and my court. There was 2,072 cases, and of those, 47% had court-appointed attorneys. And so there's a big need for attorneys in our county. When I started back in 2011, my court had about 20 to 25 attorneys who did indigent defense, 20 to 25. Last year, it fell down to 5. Right now, I have 9. What happened to them? I heard presenters say today, most of them retired, died. Some of them just got out of the practice. It doesn't pay to be an indigent defense attorney. You were talking about figures. In my court, we pay $250 for a time-served straight plea, $300 for probation. Not many people want to do that. And so when you have only 5 attorneys, and today 9, they take on like 60 to 70 cases in addition to their own practices. And again, they're not making any money handling my cases. And so I'm here today, as Scott will ask you in a little while, ask us, why do you want a public defender's office? We need help. We need money. We need support. And so I'll talk more about that as we get going. But it's a pleasure to be here today.
Great. Thanks, Judge Spinrath. I'm going to start off with you, Judge Ferguson. As you had mentioned, you're in an ultra-rural county or ultra-rural part of the state. Multiple counties your district court was covering. Could you tell us a bit about those counties and the indigent defense challenges that you had before there was a public defender office out there?
Sure. So we do have 5 counties. If you remember the 2 maps that he put up, I'm sure you were all paying close attention. On one of them, there was a huge red swath, kind of like the shape of California. That's my district. There's no added to it. There's nothing taken away. That red is the 5 counties of the 394th. You may also recall in his other map that showed where there were overloaded lawyers, it was white. And y'all are thinking, wow, what are they doing right out there that they're not overloaded? It's because we created the Far West Texas Regional Public Defender Office, who handles 90% not of indigent cases, but of all felony cases. 90% of felony indictments, those defendants out where we are represented by our public defender. The reason is this. There are 13 towns in the 5 counties. The largest town is about 7,000 people. The smallest, depending on what time of day and whether the kids are in school, is probably between 50 and 150 people. And some of you may know Valentine. People go there to get stamps to send their Valentines to their significant others. That's also in the district. It is 20,000 square miles. It would be the 10th smallest state in the United States. But it only has 25,000 people of all ages, not adults, not voters, not potential jurors, everyone from birth to death, 25,000. It is 21% of the U.S.-Mexico border is in my single judicial district. Not Texas, Mexico, but U.S. Mexico. It is a very poor area. It is an area with no services. Now, of the 5 counties, 2 of them have 0 lawyers. Not a prosecutor, not a county attorney, 0 lawyers of any kind. The other 3, 2 of them have 1 practicing lawyer in private practice, and the other is Alpine, which has 3 to 7 probably. Part of the problem we have getting lawyers out there is the competition with the federal courts. And we have 13, I think, different checkpoints, either floating checkpoints or on the border or on the highway. You've heard of the checkpoint of the stars, I'll bet, the one that got Willie Nelson and Snoop Dogg and Fiona Apple. That's on I-10 in my district. So every car on I-10 gets pulled over, sniffed by a dog, searched maybe. And so you can imagine that in a county of less than 2,000 people, we get hundreds and hundreds of indictments for drug possession, because every car gets searched coming out of New Mexico and Colorado where stuff might be legal, and Texas refuses to acknowledge it. So we have no lawyers. Before we had the public defender office, the number of lawyers we had was whittling down. The older lawyers were dying. Younger lawyers would move in and have no one to mentor them. They had no services and no help, and they would stay until they got embarrassed and realized they can't do this, and they would leave. And so the numbers started to dwindle. It got so bad that I started personally calling friends from across the state and begging them to take a case, because I didn't know what else to do. I called them and said, "Can I force lawyers to take these cases?" And they said, "No, you cannot force lawyers into servitude." So I didn't know what else to do. When I took over that job, Hudspeth County, which had no lawyers and was an hour and 10 minutes from El Paso, paid $200 flat rate for a felony case. Whether you tried it or pled it out, no gas, no mileage, no assistance, no services. $200. Raise your hand if you want to work for a year on a felony case and go to trial for $200. No hands will ever go up to that question. So it was bad. The highest rate we had was $85 an hour, which was in Brewster County, which has that bigger city, as you pointed out earlier, in it. And so there's no money. The counties are exceedingly poor. Every dollar is stretched into $1.05 because it has to be. And so these cases that would go to trial, the lawyers don't make anything, but it's staggeringly expensive for the county. Just calling a jury pool was too much. And then if there was an appeal, you had to appoint an appellate lawyer. And the cost for those is $10,000 sometimes if you went up on appeal. The lawyers, well, I did raise the pay rate to $100 an hour flat for all appointments. CPS started out, I think, at $35 an hour. They paid the lawyers for CPS representation. And I raised all of them up to $100 an hour in or out of court. It did not help. It's not enough. And the reason is the lawyers would starve to death if all they could do is work on these cases at $100 an hour. And so they're trying to feed their families and keep their kids in school with a private practice on the side charging $275. And I'm asking them to take a case for $100 an hour that the county judge might refuse to pay, right? So I'm not blaming them for this. It is the lowest priority in the daily life of a lawyer who has all of these people to help. They may be the only practicing lawyer in a town of 3,000 people, our county, the only one. They're handling every probate, right? Every divorce. They're in those cases. And I'm here throwing felony indictments at them for drug possession. Oh, one more thing. The third thing is people like to say judges call balls and strikes. Rural judges do not just call balls and strikes. That's what you do when you're in trial. The rest of the time, you oversee the entire justice system in those communities. There's one district judge, 5 counties, 5 commissioners' courts, 5 county judges, right? Every one of them has a juvenile docket. My job is to make sure that system works and that people aren't getting railroaded or run over when they are dragged against their will into that system. Part of that means I have to watch the jails and I have to watch law enforcement. And that is something that a judge cannot magically do through some sort of intuition. We have to have people on the ground who can tell us what's going on by talking to their clients and seeing the discovery. And it was something I could not do when I had no consistent, let's just say consistent bar working daily with those jails, the 4 jails in the district, and all of these different prosecutors and county attorneys. And so the system just collapsed in upon itself. Is this where you want me to mention why I did the, okay, we'll do that later.
Not yet.
We'll do that later.
That's the next question.
There's our challenge.
Judge Spinrath, so you're in Wharton County, and it's not quite as big geographically as Judge Ferguson's area, but you're rural nonetheless. You're pretty close to the suburbs of Houston, as you mentioned, and so I'm wondering what kind of indigent defense challenges are you facing right now in Wharton?
No one really wants to practice criminal intensity. People are willing to, young attorneys that come probate, contract cases, things of that nature, but criminal, they don't work with the clientele and stuff. So what we end up getting, not necessarily practice, a lot of them move or 30 to 40 miles away. What they do is they first go and get on the first county, bigger one, then they'll reach out and they'll get on the wheel, Matagorda and Wharton and Colorado. So when magistrate people weekends, they're assigned an attorney right away. So the attorney is sent a letter or an email notifying them they have a client. These attorneys, as they cutting their teeth and they're building their practices, they work more at home. They work more in Harris County where there's paid more, but they have more clients. And they oftentimes tend to forget about people that have been assigned far away. And so, number one, there's a shortage of attorneys, but then there comes the problem of the attorneys never show up. There's been situations where someone can't afford to bond out of jail. And this has happened a few times, and the jail will call me and say, Judge, the attorney's never come and seen this guy. He's been in jail for 10, 14 days now. You can't have that. That's ridiculous. Or a client will, an inmate will bond out of jail. They'll be given their attorney's information. They'll contact the attorney, set up an appointment, or the attorney won't call them back. And the next thing you know, it's 3 weeks go by. They finally get a hold of the attorney, and the attorney says, look, I live in Harris County. You're going to have to drive an hour to get here. And they go, I don't own a car. I don't even have a house. How am I going to get there? Well, that's your problem. And so what the attorney tells them, look, I'm going to file this waiver of arraignment. So you don't have to show up for your first appearance. We'll reset you. So we reset them 2 months out. So now it's 3 months. You know, the first month and then the 2 months, and now it's 3 months out. Now I can't begin to tell you how many motions for continuance I get at the 3-month mark. Or one of the 4 locals, we have 9 attorneys, 4 local, 5 are out of town. One of the 4 will step in because they got a phone call. Will step in and talk to the client and then tell me they want to reset because the county court that area, another city. And so now we reset another 2 months down the road, and these defendants keep coming to court. So we make them come to court, and they're madder than you know what. They're like, I've never talked to this guy. I want another attorney. I can't pick here. I don't have a lot to choose from. And so what ends up happening is the next problem, then the whole legal system starts to stall down. And now I got cases, when I started to have 600 cases on my docket, now I have 900 cases on my docket. And it really, it's district court where the big problems are. I scheduled 38 trials this year because I've learned if you don't call a trial, they're not going to work on the case. And so what happens is finally the time for the trial comes. Now we're 5, 6, 7 months in, and they work out a plea agreement. It could have been done 3 or 4 months ago. And so not only do they work out a plea agreement, but most of the time that attorney doesn't even show up. He gets one of the local people. Over the phone, he's worked out a plea agreement with the prosecutor, and then he gets someone to stand in for him. I didn't turn my microphone on, did I? Shame on me. And so he gets someone to, I'm getting excited here. He gets someone to stand in for him locally to go over the plea with the client and everything, and the next thing you know, the client's gone, and I've never even seen the attorney. But I'll be careful and I'll ask the defendant, are you good with this attorney stepping in for you today? Are you good with, you understand the plea? I'll go Blue's Clues it. I'll make sure they understand everything. By that time, that person's so mad, they just want out of the system. They're like, just free me and deem me, let me out of here. And so that's another problem that we have. Well, not only then is the whole legal system binding down, but then the jail's overcrowded. And so we have 144 beds in our jail. The last 2 years, we've been averaging 153 inmates. And so we're shipping them to other counties at $60, $65 a day. And now the other counties near us have the same problem, so we're even looking to ship them to Louisiana. Can you imagine driving someone 3 hours over, 3 hours back just to visit with their attorney, take them back 3 hours, just the cost of that? And so finally, we're at a point now where our jail's overcrowded, and we got a variance from the jail commission. They gave us 16 more beds, but they gave us variance twice, and they said this April, next month, you come back with a new jail. And so what's the answer to that is we've got to get the legal system kick-started. Is everybody I'm talking about have indigent counsel? No. But we've got to keep people moving. We've got to keep the system moving so that we don't bog down. And so those are the biggest problems I see. There's not enough attorneys. The ones that we do get are young, inexperienced. They don't always show up. It slows down the judicial system, mainly in district court. And then the jail begins to overcrowd. Of my cases, of my 900 cases, and that may be a lot, 450 of them have attached felonies. There's 450 of them that I can't deal with because they have a felony that is related, and if they plead to this, it could be used against them. So I'm stuck. And so we need help. We need more attorneys. And I tell you what, if we pay them better, and that's what I need your program for, they'll work harder, they'll be more motivated, and they'll show up.
Can I get an amen?
Stephanie, I want to get you in here. You've got a little bit of a different perspective from the two judges, and you've been working for a public defender's office in both an urban area as well as now in rural Atascosa and surrounding counties. What kind of challenges have you seen both, in Bexar County when you were practicing there, as well as what you're seeing today in Atascosa, and maybe before you got there and started fixing things?
Both counties had similar problems. We saw issues with stakeholders being opposed to us. The commissioners were not as excited about having us there in either place. We had problems with our clients not wanting to have public defenders represent them because all they've ever heard is that a public defender doesn't do good work. We've had problems with the local defense bar opposing us because we were going to take all of their money from them. This was specifically in Bexar County. I was approached by several defense lawyers in Bexar County asking what were we planning on doing? How were we going to manage to take all of the cases in Bexar County within the public defender's office? And after I explained how we were managing to take on initially 1,800, maybe 2,000 cases out of the 40,000 cases filed in the county, they kind of sort of understood we were not there to take over, but to help. So those same problems were existing in Atascosa County. Commissioner issues, local defense bar, the lack thereof, and of course there were issues with pay. Once Bexar County got on board and realized that there was a benefit to having us there because cases were moving, clients finally realized that there were people committed to having us represent them, having a public defender represent them was in their best interest, then things started getting better. But still, we were having issues hiring people because there's always the issue of money. And there's this sense that defense attorneys should not ever make as much money as prosecutors. Prosecutors are more important than defense attorneys. I've had people tell me that, people who are in charge, authority figures, tell me this as if they know of what they speak, and this should be the law. And I've had to correct them and let them know how wrong they were. But those are the major problems we had going into beginning the offices. I was fortunate when I started with Bexar County that the office had already been established. It just needed to be built. So I came in on the ground floor, and I started with the magistration division, where we only represented mentally ill indigent clients. And they were only cases that were first-time offenders for the majority. They could not have any prior cases in the system anywhere, and they could not have any violent offenses. So that started out making things a little bit difficult because 99% of the people who were arrested were those people with all of those things that had been excluded. So it was a slow start in the beginning, but once it got going, once the stakeholders saw that we were making headway and we were doing good work, it got a little better. The rules started changing. Eventually, we were able to represent those clients who did have prior cases, those clients who were charged with violent offenses, and the stakeholders and all of the other important people realized there's a benefit to having us. You know, I'm listening to Judge Spinrath complain about all of the issues he's having, and my heart goes out to him because everything he's complaining about would be resolved with a public defender's office. I've seen it happen, and I know it's possible. But our challenges were there, and I was not surprised to see the same challenges when I moved from the urban area to the rural area. But what I realized when I got there was that we had achieved it once in Bexar County, and I was going to achieve it again in my rural areas, and we've done just that.
Great. Judge Ferguson, I'm wondering, I mean, I think I got to have a good sense of this, but what led you to decide you wanted to create a public defender's office to serve your court and those counties in far west Texas?
So I mentioned earlier that judges have a broader, a grander job than just making sure cases move and calling balls and strikes. Our system works not just because justice is done, but because justice is seen to have been done by the community. If the community does not perceive that the system works, that they were adequately represented, that justice was done, even if they don't win, even if they're convicted, it's called procedural due process. If they don't feel like their rights were protected irrespective of the outcome, then the system falls apart. And it was my perception when I took the bench 13 years ago that we were falling short along the border, that people would joke about getting pulled over for a ticket you may not get home from spring break for 6 months because the system wasn't working. And so I knew that if that's what the community thought, the defendants themselves must be just despondent. And I was seeing that docket after docket. When I would say, your lawyer's not here, did he tell you that he was coming? I haven't talked to my lawyer since last time we were in court. I had lawyers come up to the bench and say, would you call out my client's name? I don't know what they look like. And I'm not talking about at arraignment. I'm talking about well into the case. So defendants were not being well represented, and they were getting angry. Every single month, I would have multiple lawyers asking multiple defendants asking to fire their lawyer and get a different court-appointed counsel. And I didn't want to say it, but the bottom line is it's not going to be any better. This is the way the system is operating. So the cases are bogging down. One thing that causes defense attorneys to bristle, but as a judge I can say it, when lawyers don't know their client's case, they don't work the case hard enough, they cannot adequately represent them and advise them on whether to take a plea or not because they can't evaluate their risk at trial. They can't evaluate the odds of a sentence. And so they literally will just turn to the person and say, hey, here's what they're offering. Do you want to take it, yes or no? The person's like, why would I? I don't want to go to prison. The answer is no. And then that case goes to trial, and they get hammered. One time I had a lawyer come up, and he was complaining at me about something, and I said, well, what's your defense going to be? And he said, we don't have a defense. I said, then why are we at trial? You know, and of course, once he actually understood the case, he pulled his client aside, they reached a plea agreement right there in the courtroom with the jury panel waiting, right? And it's because the lawyers don't have the time. You watch the outcome of these cases swirl. I do a very thorough plea hearing, and they've seen me do it. My plea hearings are not 30 seconds. They're more like 12 minutes. And I walk them through all the collateral consequences of entering into these pleas, even if it's a 1244B. And invariably in a docket where I took 80 pleas, I would have 3 or 4 people turn to their lawyer and say, you never told me that. I can't take this plea. I'll lose my driver's license, my CDL. Well, I'm a nurse. I can't take this plea. I won't be able to be a nurse anymore. I'm a college student. I'm on grants, right? These things should never happen, and it started weighing me down because if I didn't do all of that, I could be sending an innocent person to prison. I could be taking away the opportunity for lifelong education from someone just because the lawyer didn't do a good enough job. The other problem we had that really snapped it for me was lawyers weren't going to see the defendants when they were appointed. They're supposed to do it with, 24 hours, 48 at the outside. They weren't doing it at all until the person was indicted. And then they would come before me and I would say, do you have a lawyer? I don't know. How long have you been in jail? 4 months. You didn't bond out? No. Never knew I had a lawyer. No one's been fighting for me. And so they're not showing up. They don't know their clients. And people are sitting in jail driving my 5 county judges and 5 commissioners' courts. Ponder that for a minute, Judge. Crazy. And I'm getting it from all these different directions. One more thing I want to mention real briefly is on child welfare. Some of you may not do child welfare work. I see Dylan's arrived, and he certainly does. You're going to hear from him later. But in a criminal case, you've got one attorney for one defendant, right? One person, one case, fine. In a child welfare case, you have 3 lawyers minimum appointed. One for the kids, one for the mother, one for the father. Sometimes we have one mother, 2 kids who disagree, so that's 2 more lawyers, that's 3, and then they have 2 different fathers, and so that's 5 lawyers in a county or district that doesn't have 5 lawyers, right? Those cases last 12 to 18 months. They don't wrap up in 90 days with a quick plea like y'all can sometimes do. These cases last a year every time, sometimes 18 months. Now imagine the cost to the county judge over there who's watching these happen. And by the way, they get a mandatory appeal if they lose, just like criminal defendants do. So all those parties, 5 parties, going up on an appeal because they all lost their case, $50,000 in a county whose annual budget for indigent defense is $25,000. Okay? Something had to be done. That's why.
That's why. Something had to be done, something had to be better, and it was a public defender office that you decided. You must have heard something from somewhere about how great public defender offices were.
I know we're getting to that in a minute. I'll tell them this. My first week, it may have been my first day in office, and I think, is Edwin still here? Was it the first day or the first week? I never can remember. It was right there. One of the first things I did when I took the job and literally didn't know what I did for a living anymore, I walked into an empty space with no computer and thought, I don't know what I do now. I picked up the phone and I called TIDC. And I asked Edwin, who took my call, I said, how do I make sure that people's rights are protected? Because I don't think it's happening. And so we talked about it, and they walked me through with some ideas and sort of planted the seed of there may be other ways. And then here we were 8 years later or 7 years later when I snapped and made it happen. But we'll talk about that in a bit.
Great. Stephanie, you were in Bexar County in the early days of before the public defender office. What were they thinking? Why did they think a public defender office was going to be the best solution for whatever was going on in Bexar County at the time?
As I mentioned earlier, the initial thought was mental illness was a major focus during this time, so that their thought was we will help as many mentally ill indigent people as possible. And so we decided that the best way to do this was to work with the Center for Healthcare Services, CHCS, to ensure that they would get the right type of treatment, the right type of housing if possible. We would try to get them jobs. They wanted to make sure that these people were receiving the type of help that would keep them from being unhoused, because that was a big, major, huge issue around Bexar County, as it is in a lot of major cities. But Bexar County's attack for this, or solution for this, was to try to get help for as many people who were being arrested. Because what you find is they were arresting people for Class C misdemeanors and things like that, that would not really give them jail time, but it was for minor issues that they shouldn't have been arrested for. And because they were mentally ill and they had nothing or no one to help them, they would just be right back out on the street doing the exact same thing, getting arrested again. So Bexar's solution was, actually, let's see if we can help the mentally ill indigent, get them the help, get them the treatment, and perhaps keep them off the street. And it actually worked, because we were able to follow along with a lot of our clients initially. We got to see where they were living. Once we determined there was housing for them, we were able to determine the types of jobs that they were capable of doing, and seeing that they did receive help. We followed a couple of our clients on video for several months to make sure that they were doing what they were supposed to do, and it was a great outcome on all fronts. Talking to the judges in court, they were happy to have us there, because we were not always there to ensure clients were put on probation or that they received a lesser amount of sentence. Our goal was to make sure these people were not going to deal with any type of jail or probation. All we needed to do was make sure that they were going through their mental health treatment. And if they did what they were supposed to do within that certain amount of time, there were a great many cases that were dismissed. That was the achievement of all of our cases, if we could get there. Sometimes it worked, sometimes it didn't. But initially, we went in looking at the mental health component, and it worked. And I didn't mind when I took this job. When I saw that job posting in the paper, I thought, oh, it's all about mental illness and, mental health issues. I realized this was the job for me. My brother is mentally ill. And so my family, as I mentioned earlier, they're all public servants, and they've all worked in some component of the system where they were helping people on probation, or, my mother was a special ed teacher. Her brothers were special ed teachers. So we've all had that moment in our lives throughout my childhood where we were dealing with some aspect of it. But my brother was the biggest issue for me in this calling, because of his laundry list of mental illnesses. You name it, he's got it, including alcoholism, drug issues, and everything in between. He is doing quite well, so don't worry, he is doing very well. My brother stabbed and killed our mother 13 years ago, and he had a public defender to assist him on his case in Tennessee. And this public defender worked his behind off to ensure that my brother was treated fairly and got everything that he deserved, in the sense that he was mentally ill. 6 doctors said he would never be competent to stand trial, and he was not. He did not stand trial. The case was dismissed. The charges were just obliterated, and my brother is living in a home in Nashville, Tennessee, where he's cared for by around-the-clock personnel. He takes his meds on a regular basis, so he has housing. He's not unhoused. He has transportation to and from all of his appointments. I go see him every 4 to 6 weeks. We stay in touch, and this is what the system can do if it is done right. So I know that this is my personal calling, not because of my brother, but because of all the people that we do help in the system.
Thanks, Stephanie. Judge Spinrath, you don't have a public defender office at this time, but I know you've been trying to get one. I mentioned earlier that we unfortunately couldn't give you any funding last year, but why a public defender's office? Why do you want to go that route?
Certainly. Let me touch on two things first. Something Judge Ferguson said just made me smile because I totally agree. In our family courts or our CPS courts, last year we had 772 cases, and 77% of them had court-appointed attorneys. And when you talk about court-appointed, you're right. I walked in on one courtroom, and there were 6 attorneys there representing everybody, and they were all paid for by the county. And so that's certainly an issue. The other thing I want to do is quickly tell you some things I tried to do or we tried to do to fix this. The first thing I did several years ago is I appointed what was called an attorney for the day. There was an attorney who was in his 4th or 5th year, and I asked him if he would, on my Wednesdays where it's status hearings or arraignment dockets, if he would just come $500 a day for the first couple hours and just talk to anyone who had questions. A lot of people who come into my courtroom, and I would think most courtrooms have never been there before, and I have misdemeanor court, and then they don't know what to do, and they just want to ask somebody some questions. And they end up coming up and asking for a court-appointed attorney when if someone just answered 1 or 2 questions, it would have been fine. And so I tried to do that, and then the local bar got on me because they thought it was unfair that he got to talk to all the attorneys, but we'd made a deal where he couldn't, anyone he talked to, he couldn't later be retained by. But anyway, that kind of fell through. The next thing I did is I fought the commissioners, and I doubled the fee schedule. Now, don't laugh, but we went from $125 a case to $250 a case, if that was a time-served plea, and we went from $150 to $300 a case if it resulted in probation. There's nobody still going to want to work for that. And if there was a case that had 3 or 4 other charges with it, you got $50 a pop. And so those things just simply weren't working. So why a public defender's office? I think I jumped all over it a while ago, but I'll just start with show me the money. Scott, you've got the money, or somebody's got it, and I want it. The program you have, that as you explained it to me and I understand, pays 80% of the first year's expenses. Now, there are some cases that can't be covered under the program. There's going to be conflicts of interest, and I understand that. But still, we paid $900,000 last year in our county, and we're a smaller county. If you could pay me not 80%, but 50% of that, we're saving hundreds of thousands of dollars. And then I know in the following years it drops to 60%. But the big thing right away is the money. The second thing is you're going to get good quality attorneys. And probably the most important thing about all of this, and I loved your story, and thank you for sharing that, is defendants need someone who's qualified, someone who's motivated, and someone who cares about them. And they're not just there for the quick $20 or $50 or whatever. And so by offering a higher wage, which your grant can allow us to do, we're going to get cases move faster, and people are going to really get taken care of and represented. And Judge Ferguson, you made me laugh a while ago too, or whichever one he said, but I think it was Judge Ferguson. When I was explaining to this, and Scott, you've met my county attorney at least on video or whatever before, when I was explaining this whole program and why it was so good, and I told him about this, we're going to be able to pay our attorneys more than $250 a case, and we're going to have salaries that are commensurate to area counties, and he looked at me and said, you can't do that. They'll make more than the prosecutors. This program's just going to stop right here. So I hear you. I just laughed when you said that. I hope he's not watching this because we're good friends. We may not. But with good attorneys out there, we can kickstart the system, like I said a while ago. We can move cases faster. I'm going to have more time to spend on budgets and public infrastructure and emergency management and other things because I'm not caught in these status dockets and just the judicial things. The local taxpayers are going to save hundreds of thousands of dollars. Not just on what we pay attorneys right now, but on what it costs to house inmates. Because as I told you earlier, some of those people stay in the jail 2 or 3 days later, and when they're in there, not only do we pay their food, we pay their medication. And if they're pregnant, if they're a cancer patient, or whatever, we have to pay those costs as well. So there's better representation, but also there's the opportunity to save so much money. So, Scott, you know, what is the reason? Well, there's a lot of reasons, but show me the money. I want your money, man. You have a wonderful program. The only thing I can look at today and say, what is a lifeline that could save our sinking judicial ship? It's your program. And again, not everyone is indigent. but we could relieve so much with that. Now, let me quit with this. Wharton County is the greatest place on earth. We believe it is the #1 rural county in the country. We have beautiful schools, great people. We want you to come live there. So when I sit here and complain about judges and criminals and that's just that much of our population. So come spend your money and come play with us.
Thank you, Judge Spinrath. We are technically supposed to end right now, but I cannot end right now. We have a little break built in here, so I'm gonna steal a little bit of the break, because I don't think that we've really dug into like all the benefits that you saw, Judge Ferguson, once the public defender office got up and running in your ultra rural counties. So if you could just tell folks, tell them, some stories and some of the benefits you immediately saw.
So I'm going to talk to everybody in the room and on the live stream, but I particularly want our elected officials, our legislators, to hear some of the things I'm saying now. If you haven't tuned in yet and you've been doing other work, I'd like you to tune in and hear this, because what we're talking about is taking care of your constituents. We're talking about defending the rule of law and ensuring that the system operates fairly, so that innocent people aren't convicted, and so that punishments fit crimes. And what I will tell you is that the creation of our public defender office, it revolutionized justice there, because it did away with the generic punishment. And those of you in the system know what I mean by that. The generic punishment is, this is Mr. A, he gets 3 years. And then this is Mrs. B, she gets 2.5. Because it wouldn't be justice to get 3 years, but at 2.5, well, that's got to be justice, right? And we're going to negotiate, okay, fine, 2 years and 2 months, right? There's nothing about the person, about the defendant or the victim, that's connected in any way to that kind of punishment. In order for defense attorneys to ensure that punishment, if it's appropriate, benefits society, benefits their client, is they have to know the person, they have to investigate it, they have to talk to people, they have to know whether there's a mental illness. What is it, 75+% of people that are incarcerated in the penal division have diagnosed mental illnesses, right? In my area, the vast majority of repeat offenders and almost every CPS removal was meth-based. Well, you cannot tell me that putting someone in jail for 3 months and then giving them a 1 or 2 or 3 year probationary period is going to help that person. We know the numbers in this room. That person will not be helped. You cannot defeat meth by checking in every other week with a probation officer and testing dirty on a UA. That is deferred incarceration for drug addicts. If we want to help people, we have to have a system that has the time and the resources to look at the human being who is involved in the case and craft something that both satisfies all of the goals of the criminal justice system, but also helps that person so that there's no recidivism. You want to help people in the community, ensure that no one does it again. Right? It's the repeat offenders that we see over and over. Oh, Mr. Smith, I see that you're back again. This is your 8th arrest that you've had on meth charges, right? So that's the main thing, is getting rid of generic punishment. 2 other things I want to talk about briefly. The balancing of the scales. And it always entertains me, and Judge, I hear this all the time too. They want to compare salaries. Compare the salaries. That's not how we should compare. I think they should all be paid equally, personally. I've done everything I can in my district to ensure that the DAs are very close to our public defender salaries. But the goal is justice. The goal is not equal pay, right? What we want to see is better outcomes and a level playing field. In our district, there were no services. There were no investigators. There were no social workers. There's no mental health facility at all. There's no one to do evaluations other than MHMR, and you're lucky if we can get that process working correctly. If they do diagnose someone, they don't know what to do with them because there's no treatment. There's no counseling. There's no drug treatment facility. They were alone, these defenders, these lawyers. Our system now, the PDO, 2 social workers, 2 investigators. The third thing dovetails straight into that. Some of you may have heard, but having our public defender office has allowed me to improve the system as a whole. We found out there were abuses going on in some law enforcement, some prosecutors' offices. That was brought to me by James McDermott, our chief public defender, and Paul Chambers, who discovered these things were happening. And sure enough, they were. And those of you who keep your finger on the pulse know that in December, I issued an order finding systemic and systematic violations of the discovery and Brady rights of criminal defendants in my district who were being prosecuted by the El Paso Assistant DA. If you haven't seen it, look it up. I will tell you that when the new DA won election and took office, he dropped the appeal and all the challenges and said, we're going to use this as a framework for how not to do that anymore. The reason that happened is because our public defender's office put in the work. They had the guts to file the motion. We had a 3-day trial, and who was on trial was the DA's office. That's who was on trial, right? We've had to institute automated systems for magistration because magistration paperwork was not making its way from the jail to my office. We were having trouble ensuring that all of the people in jails showed up on jail rosters. And so we had to do something. And so that spurred me to create the automated online magistration portal where every magistration goes into a laptop live while they're in the jail. It goes into a spreadsheet, and I can look at everything that happened. I know whether they applied. I know what they earn. I know what the charges are, what their email address is. I know the time they were magistrated and the time the magistrate says they were magistrated, by the way. Those kinds of improvements to a system only happen if you have a public defender or a group of lawyers who have their finger on the pulse every day of what's happening. They get to know the people there. They talk to their clients frequently. We had a group of people that were lost in the system because they weren't on a jail roster and didn't have any criminal charges. And the only reason I found out and got them out of that situation was my public defender was meeting with another one of their clients. They didn't have these people. And the guy said, hey, while you're here, is there anything you can do for those guys? They've been here for over a year and they don't have lawyers. That's how we found out. They were going to be there forever, right? So it improves the entire system. It improves the outcomes. Jail sentences are shorter. Prison sentences are shorter. Jail stays are shorter. People get out quicker because the public defender's there every day talking to someone, trying to get them bonded out. It's cheaper for the county. It's better quality justice. It brings the dockets down, and it improves the system as a whole. So you want 4 reasons to have a PDO? There you go.
Thank you, Judge Ferguson. Stephanie, real quick, how have you seen things improve in Atascosa and your counties that you serve, thanks to your public defender office?
What he said. It's also very true. I have a group of wonderful attorneys who work for us, social workers, 2 investigators, as I said. These guys are committed. Everyone in that office comes to work every day with a song in their heart, happy to work in our office to represent our clients. You mentioned resources. The major resource, time. Because we're not dealing with our own private practices, we have the ability to spend as much time with our clients as we want. We can see them as often as we want. We can talk to them for as long as we want. We can do everything under the sun that the typical criminal defense attorney cannot do because they're always worried about time and how they're going to get paid. That is not an issue. We are not getting paid as much money still as the DA's office, but it is still better than it was before I got there. But regardless of that, these people were still committed to doing exactly what they're still doing when they had less pay. If you can get motivated people in your office to work for you and not give a care about how much time they're spending or the amount of money they're working, then you've created a successful public defender's office. If you've got the staff to guide you, to be behind you, to be committed to everything that you need to make this office thrive, you've got a successful public defender's office.
Thank you, Stephanie. Any other closing remarks?
I'm just excited. He got me at, they'll be there every day rather than every 40 days. I'm just thrilled about the possibilities. We need help in everything that you said. The defendants need proper representation, motivated representation. It helps the public. It helps the taxpayer. We need you, Scott.
Judge?
All right, I'll close with this. And to our legislators, one more thing. Everyone in our situation is telling you the same thing, which is this system is vastly improved for all the reasons we've told you. But for those very same reasons, we're not telling you there won't be pushback, because there will. The people who benefit from and rely on a bad system will do everything they can to keep that system in place. And so there will be pushback, and there will be battles that will arise. Sometimes those battles don't arise until the public defender's office starts winning trials. And suddenly, something's wrong here. Justice isn't being done because we're getting acquittals instead of convictions at a 98% rate. So we're not saying you won't get a call from someone complaining about the idea or the program. What we're saying is, if you didn't, the system wouldn't be working as well as it does. The fact that it works is why some people will push back. And we encourage you, I encourage you, in your areas that lack adequate representation and lack the number of lawyers you need, to be open to this, to call TIDC, to talk to us, and find out whether it's the right thing to improve the lives of your constituents. Thank you for having us.
And it all begins with TIDC.
Oh, well, thank you. Well, thanks for joining us, Judge Spinrath, Stephanie, Judge Ferguson. We're running a little behind. We will get off stage, and we're hoping to start here like in the next 5 minutes. Okay, thank you.
Thanks, folks.
Do you want me to start now? Okay, we're just going to go ahead and get started. We're going to roll right into the next one. So thank you everyone for being here, and thank you to everyone who's listening online, and for people who are watching the recording. We appreciate you spending your time with us. We are really excited to talk about a very important issue. We are here to talk about what we call family protection representation, which is basically the legal representation of children and parents in child protection cases. As you heard in an earlier presentation, there is currently no state funding to support that work. So all of the lawyers who are representing kids and parents in these very serious cases are being funded 100% by county dollars. And the system is in deep need of support. And we are going to talk here today about capacity issues and possible solutions. I'm really excited to have this wonderful panel with us here today. So sitting with us here, we have Judge Elizabeth Watkins, and she is the judge of the Child Protection Court of the Concho Valley. Judge Watkins' court covers Brown, Koch, Concho, Irion, Runnels, Schleicher, Sterling, and Tom Green County. She covers all of those. Prior to taking the bench, Judge Watkins served as the Family Justice Director for the Williamson County Attorney's Office, a regional attorney for DFPS, which is Department of Family and Protective Services, for those of you that don't live in our world. She was an assistant DA at the Anderson County DA's office and was also an investigator with DFPS. Judge Stuckey, who's over on the end of the table, is the judge of the Centex Child Protection Court South. Judge Stuckey's court covers Caldwell, Colorado, Gonzales, Guadalupe, and Lavaca counties. And prior to taking the bench, Judge Stuckey was a regional attorney for DFPS. We also have Dylan Minch, who's over here in the middle. Dylan is currently the chief counsel for the Travis County Office of Child Representation. Prior to taking that position at OCR, Dylan served as the legal representation director for the Children's Commission of the Supreme Court of Texas, and Dylan also worked as a mediator, a staff attorney with OCR back when it started, and as a private attorney representing children and parents. So we're really excited to have this panel here. They've taken the time out of their day to come and talk about some really important issues that they're facing on their benches and in the courts that they serve in. And before we get started, I just do want to note for people who are unfamiliar with the work, in Texas, we do have statutory rights to counsel for parents and children who are involved in child protection cases. These statutory rights are found in the Family Code, and those basically say that children and indigent parents who are involved in suits that are filed by the Texas Department of Family and Protective Services, and we're just going to start saying DFPS, or most of us say the department. When we say that, that's who we're talking about. The code says that when there are suits filed for termination of parental rights, conservatorship of the child, meaning DFPS wants to take the child into legal custody and take them away from the parents, orders for required participation, and also a family preservation service pilot, those all require lawyers in those cases. And they also require a lot of lawyers, which we'll talk about in a minute. And as we said, right now that cost is being shared completely by the counties, and unfortunately the House Article 11'd our request earlier today, so it'll be important that people think about how important this work is. So let's get started. All right, so before we get into some of the capacity issues that we want to talk about, I thought it might be helpful for y'all to understand how our court system works in child protection cases. So both Judge Watkins and Judge Stuckey cover what are called child protection courts, and Dylan is in a county that's not a child protection court. And up here on this slide, you can see the map. The colors are all the child protection courts, and they're color-coded by the different court, and then the white counties do not have a child protection court. So we have kind of this mixed system. So to start off with, I'd like both Judge Watkins and Judge Stuckey to talk about their courts, kind of how they operate, how they function, so that people have an understanding of their day-to-day life. So Judge Watkins, since you're next to me, you want to explain your court first?
Sure. Yeah, it is. So it's actually two different regions. One is the Concho Valley, which is 7 different counties, and then the other is Brown County. Interestingly, to those of us who are in this world, I am one of the only judges that is in a region where I preside over cases that are filed by the department and done by the department, and then in Brown County, they're filed by the department and then done by a community-based care organization. So I have two very different systems, and the lawyers that practice in those courts have to know how to practice in those very different systems. But what will happen is the department will file a petition for removal. It'll come to me in those counties. In each of those counties, I have a presiding judge that's a district court judge, and they have ceded all of their cases over to me in the child protection court. So we start from the very basic. Sometimes we start from investigations for an order to investigate, and then we'll go all the way to adoption and post-adoption services in my court. So I will handle all of those, often in conjunction with something happening in the district court, like a divorce or a protective order issue, but we also cover protective order issues in my court. So everything to do with the child from beginning to end in a CPS case will come through me in all of the counties that I am in.
And Judge Stuckey, can you explain a little bit to the audience and people watching online how your court functions and kind of logistically how it works?
Yeah, so basically my court works the same as Judge Watkins. One of the other things I want to kind of point out is for those of us who are in rural counties, as you can see on the map, we are all traveling to all of our counties. So we physically sit in the county where our cases are being heard.
Okay. Go ahead.
Okay. So we also hear, I hear court order services, conservatorship cases, and in some cases I hear adoptions, as well as my district judges hear adoptions. Again, our cases are referred to me. All CPS cases in my 5 counties come to me originally, and then we can potentially refer a few of them back out for trials if necessary. I also hear cases that are both in a community-based care and legacy areas. And we have, a mix of district attorney, county attorneys, regional attorney representation. And as I say, I have five counties and 3 to 4 probably distinct groups of attorneys that I see that travel around with us. But we spend 100% of our time on CPS and related adoptions.
And Dylan, you're in a county that is not served by a child protection court.
That's correct.
Can you kind of explain a little bit how it works in your county?
Yes, and it's not the same in Travis County as it is in other counties that are served by a district court, but in Travis County, we do have a district court judge, Aurora Martinez-Jones, who specializes in our CPS docket. So she takes all of the cases originally on appointment, and then she also has an associate judge, Judge Susanna Castillo-Littlejohn, who assists her in those cases and handles a lot of the docket. That's not true in every district court who handles cases. Sometimes there'll be a judge who handles sort of a general jurisdiction. The judge handles every single case, criminal, civil, that comes before them. Not every jurisdiction who handles the district court has a dedicated district court docket the way Travis County does. I will say a couple other things I think that are important to understand about the district court process is that they are also in charge of the attorneys who receive appointments, both in terms of they determine whether or not attorneys are allowed to be on the appointment list, and then they actually make the appointment themselves. So that's something I think that's kind of critical to understand about the district court system, that the judges have a lot of authority and responsibility and burden over appointing attorneys for child protection cases.
All right. So let's move on to talking about different models of representation. In Texas right now, the vast majority of our state is being served by what are called private assigned counsel lists. And those are just lists of private lawyers that they call it a wheel or a list where they're essentially managed by the court system. And those attorneys are assigned to represent children and parents in child protection cases. And Judge Stuckey and Judge Watkins will explain sort of the management of those lists a little more in a minute. We do have other possible models of representation, though, that I do want to bring up before we get into some of the questions. So up here on the slide, you can see we have something called offices, I have it abbreviated, but we have Office of Child Representation and Office of Parent Representation. So Dylan works at what's called an Office of Child Representation, which she's going to explain a lot more later. That is codified in statute. We have statutes in the Family Code. They've been around for 10 years or more at this point. And sadly, since the inception of those statutes, we have had no new offices in our state started. Not one, even though those statutes have been on the books for quite some time. We also have what's called managed assigned counsel systems, also codified in statute in the Family Code. So we could do a managed assigned counsel system much like we have on the criminal side, we have a managed assigned counsel director sitting right here from Bexar County that does criminal work. We do not have a single managed assigned counsel in our state that does family protection work, not one, even though that also has been in statute for over 10 years. We also could have public defender offices that have divisions that do child protection work, either represent parents, children, a mix, that sort of thing. We have many public defender offices across our state now, as you learned earlier from the panel before. We are growing and there's wonderful work being done there. We only have 2 public defender offices, though, in our state that handle child protection work. El Paso County Public Defender has a smaller piece of that work, and then Dallas County Public Defender also has 2 court teams. I think one represents parents and one represents children. But that's what we got in our state. A state as large as ours, this is essentially the systems that we're operating with. So, to that end, since we're really running under assigned counsel lists, I'd love for Judge Stuckey and Judge Watkins to really deep dive into how these lists work and how you're managing them and what you're doing with them. So Judge Stuckey, do you want to explain, for those that are not familiar with the private assigned counsel list in CPS cases,
Sure, I'll be
how does
happy.
that work?
Okay. So in my counties, all 5 of my counties, we have all private lawyers. I keep a rotating wheel of attorneys in each of those counties. It's a separate wheel for each county. You have to apply to be on the wheel, and part of the requirements is you have to be able to show that you have the statutory required amount of hours in representing children, parents, and trauma training. That is a qualification that we hope that all of our attorneys have to get onto our wheel, but I will tell you in rural counties, it is really pushing it sometime to make sure that I keep my attorneys having their required training. I would say that our wheel, we have some really good attorneys. Unfortunately, it's a mostly aging wheel. Since I've been on the bench 9.5 years, I generally have seen the same people. We don't have a lot of, for every new person we get, we probably lose 2 people. We'll talk about that a little bit more here in a little while. Just to kind of tell you about my list, I was sharing with Crystal earlier that I have a new attorney out of law school that's in the first year of her practice. This is the first person that fits that qualification, I think, in the last 4 years on my wheel. We also have the ability to do special appointments and kind of deviate from that wheel. So that would be people that speak Spanish, people with special traits. We may have a child in a case that needs an ad litem that has expertise in educational law, so we can skip ahead and kind of turn the wheel slightly different, get that person an appointment, and then come back to the regular part of the wheel. But more importantly, part of our job is also kind of the discipline and rehabilitation of the attorneys on our wheel. So if someone is getting, it's up to us to kind of figure out when people are getting overburdened, kind of talk to them, make sure we kind of pull them off the wheel for a little while. As you can imagine, with smaller and smaller wheels, it's hard to do, but it's necessary to try to keep up quality of representation. And again, these are paid with 100% county funds. And in my counties, we have a mix of fixed fee hourly rates and a fixed fee for hearings. So in my counties, we go everything from $75 an hour up to $200 an hour for contested trials.
And you brought up a good point, Judge Stuckey, and I'm hoping you can answer this question, Judge Watkins. So in addition to all of the judge things you do, taking the bench and hearing these really intense, stressful, and emotional cases, who's managing the list? Who's sort of in charge of it?
So I'm in charge of the list. Myself and my court coordinator, who she'll be really glad that I mentioned her because she does a lot of work for me. But no, I'm in charge of the list. Anybody that asked to come on the list, and I've only had a few asked to come on the list in the last 3 years, or anyone that needs, like Judge Stuckey, a pause on their list, and it could be for various reasons. And I take it upon myself to make sure that there are opportunities, because I'm out in West Texas, for my attorneys to get that education. I will put on lunch and learns. I will forward them information that I get from the Children's Commission or Texas Lawyers for Children about online ways to get that, or I will offer to play the online at a point during a lunch and learn that I have. So I manage the list. I also help my attorneys because some of them are older and can't travel. Some of them are immune compromised and can't travel. And the ones that are younger are on everybody's list, so they're so taxed as far as where they need to be and when. I try to make it easy for them to stay on my list by providing them the information that they need to keep up to date. We're constantly talking about it. I'm constantly sending out emails about this is available, or medication questions you can ask, all kinds of things to help them stay up to date. And I think that by doing that, it helps me keep them not only up to date with what they need to know, but keep them on the wheel, because they know they don't have to go to a CLE that they have to take from West Texas. A lot of time out to just even get there. I mean, half the time you're flying somewhere from West Texas to get anywhere where the CLEs are. So I manage it, and my court coordinator manages it, and we do have to keep an eye on who's taxed and who maybe needs a break. And although there is a wheel and you're supposed to, you know, this is the next person up on your list, they haven't had a case, so they should get assigned a case. Maybe they don't get that case because it involves an infant at the hospital that they'll need to travel to see. And I have 3 attorneys that are pushing 80 that are on my list that don't travel. So I tend not to put them on cases where they would have to leave the Concho Valley area.
So is it safe to say, both Judge Stuckey and Judge Watkins, that in addition to all of your judge responsibilities, that this is an added sort of responsibility and sometimes, you know, extra work that you're having to do to manage these lists?
Without a doubt, yes.
Yeah, I would say I don't mind the list so much, but dealing with all the vouchers and payment of fees, that I could give that part up. That'd be nice.
You'd be happy to let, say, a manager-assigned counsel program handle that? Okay, and then, so Dylan, you work in a little bit of a different model, which is, we're gonna fix that, but sadly, the only model we have of Office of Child Representation in our state. But can you explain how it operates a bit differently from just the general assigned counsel list?
Sure. So our office is dedicated to what we call high quality multidisciplinary representation. And the goal is to really make sure not only that representation we provide is high quality, but that it's consistent. So one of the things that we do as an office is, I think there are some main differences between what an office can do versus what a private panel attorney can do. And I've been on a private panel, and some private panel attorneys do really great work, but some do not. And that results in a lot of inconsistency in the quality of representation that's provided and the justice that children and families often receive in the system. And so one of the first things that I think makes our office different is dedicated specialization. Our attorneys only represent children in CPS cases. Most attorneys on a private wheel often do a mix of some CPS cases, some private family, some other area of law, some criminal, to kind of make the numbers work, whereas our attorneys do nothing but this work, and that allows them to really specialize, really gain in-depth knowledge of what they're doing. The other thing that I think makes our office unique compared to attorneys on a private panel is access to multidisciplinary support. So we have 2 social workers on our staff, and we divide our attorneys and our paralegals into teams. So there's a social worker that's assigned to a group of attorneys and a paralegal that's assigned to a group of those attorneys, so they can work those cases together. And it's really key in our field because a lot of the decisions that are made day to day in a CPS case regarding a child are often very social work intensive decisions. And so oftentimes attorneys who are in private panels are sort of stuck with a choice of either sort of doing their own amateur social work that they're not really trained to do, or relying completely on the work that's done by DFPS and not really being able to do an independent assessment of what's going on. I think another thing that makes our office very different than a private panel attorney, and I can speak to this as both sides, is I remember when I was a private panel attorney, it was very lonely work. Sometimes you felt very isolated in the work that you were doing, and you sometimes try to reach out and have discussions with attorneys or friends, but those things were very sporadic. Whereas in our office, we have a staff meeting every week where we all get together, we talk about the cases together so attorneys can learn from each other in cases they're handling, trends that they're seeing, issues that they want to identify and brainstorm together. And then that knowledge lasts even if somebody leaves with that knowledge, because having just come back to our office, I'm really impressed with all of the improvements the office made while I was gone. The systems are better. Some of the philosophies are better. They're more entrenched. So that knowledge outlives any one employee at the office, which I think is another really significant advantage. And then the last thing is oversight for attorney performance. We have regular performance reviews. We talk about what is expected. And we are currently developing, we hope to publish it in the fall, a practice manual, so that not only are we internally reviewing what we're supposed to be doing, but there's a public document where people can know this is how we want to represent. These are the things our attorneys are expected to do. So that's, I think, something that's sort of built into a public office-style model of representation that's absent from a private appointment list.
Sounds amazing.
Does anyone want one? Dylan sells that pretty well. So, and just to add, we don't have someone here from the Office of Parent Representation, but Dylan, can you just, not in depth, but can you just kind of generally overview of OPR and Travis
Yes,
County?
OPR is our sister office, and they're structured very similarly. They also have social workers and paralegals. The main difference that OPR and their representation is they represent what's we refer to as the primary parent, or the parent from whom the child was removed. So they usually represent the mother in a case. Sometimes they represent the father, but it's often the mother. And so it's a certain specialized sort of representation. There's representation of fathers and unknown fathers and alleged fathers that's a little bit different. That office doesn't handle those appointments. They only handle appointments of the primary parent. I will say for their office, it's the same model of multidisciplinary support. They have social workers on their staff that are really key to helping parents, I think, understand some of the issues that are going on, because again, particularly for these clients, a lot of the issues are very social work intense. Helping the parent get the services that they need to fix whatever caused them to come to the department's attention is key to getting the children back, and having a really competent staff that knows about those issues, knows what resources available, can help identify what that parent really needs to get back on their feet is really critical.
Thank you.
Can I just say, it sounds amazing, but also it makes me kind of sad, because I know that the incredibly dedicated attorneys that I have would love to have that kind of support. I mean, they would love to have that kind of access. And what more could they be doing for the kids and the parents in my court if they did have that kind of support? It seems to me that it creates something that his kids on his docket are going to get that my kids on my docket are not going to get, because they don't have attorneys or ad litems with that kind of support. They have dedicated ones, but not that kind of support. It just seems very lopsided. So,
good point. Does anyone want to add anything before we move on?
Yeah, I will just agree. I think that's one of the hardest things, is that you don't want a child or a family's chance at being reunified, about staying intact, to sort of depend on either geography or just the random who was up on the wheel that day. Maybe you got a great attorney, maybe you got a really weak attorney, and that's not fair to families. That's not fair to have the hope of having their children reunited, the hope of a child to stay with their parent, to depend on that. So I agree. It's always really disconcerting to think about it in those terms.
Yep. Thank you. Let's talk about the hot topic, capacity. So as we mentioned, we are pretty much run by the assigned counsel list of dedicated attorneys, as Judge Watkins says, but they don't have the same support that, like Dylan's office has. And we have noticed over the years that we've got some serious capacity issues. So before we get into this, though, I would like to have a little bit of an explanation, just for those that are unfamiliar, about how many lawyers do we sometimes need on a CPS case. So Judge Watkins, if you could just give a little primer on what are we looking at? Is it just like state versus defendant, or what do we see sometimes on these cases in the need of lawyers?
So in order to have a child, there's always two parents. So at least two are needed for parent representation. I can tell you that in my court, the average number of attorneys that's needed is 4. And that is because you will often have the mom who has an attorney appointed to her, and the children who have an attorney appointed to them. Sometimes you can have 2 attorneys appointed to the children, because you may have a newborn and a teenager, and they have very different needs, and one can tell you what they want. and one can be represented, their wishes can be represented. So that may create a conflict with that attorney. So you can have two attorneys on each, one attorney for the child and another for the older child. But then you have, those two children may also have different dads. So then, now we're talking about one attorney for mom, one attorney for one dad, one attorney for the other dad, because their interests may not align. And then you're talking about an attorney for a newborn and an attorney for a teenager. So if I've got to put 5 attorneys on a case, which I have had to put 5, and I regularly have more than one dad, even if there's only one child, which
Yes.
is possible. But if I have to put 4 or 5 attorneys on one case, that's my will. I'm done. Nothing else better happen. We better not get a DNA test that says this is not really dad, and so we have to add another person in, because by then I'm out of attorneys, and then I'm scratching for the criminal courts to tell someone they have to come to my court and practice. And we've tried that, and we get better representation from the attorneys that are on my wheel, because they really are wanting to do child welfare cases. When you have to tell somebody or ask somebody else to come in and represent, you definitely don't get as good as representation. Maybe a great attorney, but this is not their wheelhouse, so to say.
Yeah. Thank you. So, Judge Stuckey, since Judge Watkins just explained how sometimes we have a huge need for lawyers on one case, what is your wheel size right now?
Okay, so it's kind of depressing. In getting ready for today, I look back. I've been on the bench 9.5 years, and I was kind of looking through, because I kind of saved the list through the years, and my lists were fairly steady, I would say, up until the beginning of the COVID pandemic. And I think, as a lot of attorneys that retire from the criminal cases also retire from CPS cases, so I've seen a distinct drop in my list since, what was that, 2001? I guess, generally that era. So in my 2 biggest counties, Guadalupe County, I've gone from 32 attorneys on my list to 13 currently. And Caldwell County, because I butt up against Travis County, I've gone from 30 attorneys to 6. And I think that's a payment issue we can talk about in a few minutes. But our lists are not just about pure numbers, they're also about, what we have. And so I also have a crisis level low level of attorneys that speak Spanish. Because what happens is, if you have a case that someone speaks Spanish, it's not one person, it's 2 or 3 people that speak Spanish. So I basically use every person I have that speaks Spanish, plus I ask nicely to somebody from a neighboring county that I have on my wheel to come over and help out. For me, the worst part of my list is the Spanish-speaking part of my list. I need more attorneys, but I really need people that speak Spanish.
Yeah. And Judge Watkins, since you've taken the bench, have you also noticed a change in the numbers of lawyers that you have to pull from?
So I've been on the bench less than that. I've only been there for 3 years, but in the 3 years that I've been there, I have lost 3 attorneys. One we truly lost. He passed away, and he was 100% dedicated to the work. And not only is that sad and disconcerting, but then because he was dedicated, he had the most cases. So I had to turn around and assign those cases to the remaining attorneys. One of them left for a short time to get medical attention, and one of them left to go from parent-children representation to work for DFPS to get benefits, because the pay is the pay. It's kind of always stayed the same, but there are benefits with the department. So I have 7 attorneys, and I'm down to, I started with 9, and I'm down to 7 that are for all of those counties that were listed in the Concho Valley. And then in Brown County, I have 5 for all of the kids and families in Brown County. And I will say, you hear a lot about the trends across the state about the cases, or there's less cases. There's only less cases because they are more intense when we get them. I have, in the last 3 months, gotten 4 cases where a parent has killed one of the children, and we have remaining children that were removed. 4 cases in the last 4 months. That is an incredibly intense case that needs a skilled attorney, that needs someone who knows child welfare. So when we lose somebody that knows child welfare and is wanting to do the work, it is very, very hard to fill their shoes. And it's very hard to, knowing that, it's very hard to get others in the legal community that this is not something that they're predisposed to do. And can I just say, if I had a person in the public defender's office, when something like that happens in an emergency, when I have to reassign 50 cases, it would be lovely to have somebody that could slide into that spot and not disrupt what my other attorneys are also working on. Just a plug there.
There is a public defender in her region.
Yes, we have a great public defender's office in the Concho Valley for criminal cases. I would love to have somebody there for family cases, for child welfare cases, for just these situations. Because people get sick, but they want to come back and do the work. And there's room for all of that, especially with the nature of these cases being so difficult and people having to take breaks. There's room for all of them, the private attorneys, and if we had that one that could take these cases in an emergency.
Yeah, that's a good point, Judge Tucky. I'm going to throw you a tiny bit of a curveball, but I think you can take it. So, just talking about the intensity of the cases and just the type of cases. Sometimes I think there's a misconception on that these are easy cases or these are like training ground cases for people. You know, can you give an explanation of sort of the types of cases you're seeing? Are they complex? Do we need people who are qualified to take these cases? Or can we just throw like any old lawyer in the room to handle this and everything will be fine?
Well, when I was in a county attorney's office a long time ago, I was the baby lawyer that was a prosecutor. And it's one thing, I think, to have a baby lawyer being the prosecutor. It's another thing to have a baby lawyer being the person who's there trying to put a family back together, representing a parent or a child. And these are extremely complex cases. As we know just from what's in the news and everything else, there's almost no case I have, whether it's a physical abuse case, a drug case, whatever it is, everything has a component of mental health. You have people who are not just have to be up in the law on child welfare, but you also have to be able to have good client interaction. You have to be able to help them, be a good advocate for them in court. This is absolutely not the place to be a training ground for attorneys. My opinion is that giving somebody to represent a parent in one of these cases that has no experience would be like giving a baby lawyer fresh out of law school like a first-degree felony. It's just not something you would do. I mean, we say if you want to be on a felony wheel, you have to do all these things. You have to show prior trials, all this representation, but I know there are plenty of places where you can just get on a wheel for CPS because we're desperate. My wheel is basically, it's kind of whittled its way down to the people that do 100% child welfare law. I don't really have lawyers that do anything else other than child welfare law. That's who I have now. The people who kind of crossed over between criminal and CPS, those are the ones that I kind of lost because there were so many criminal cases and that's what they were doing primarily, that they stayed with criminal and kind of gave up the CPS because unfortunately we pay less.
And that's a good segue, Judge Stucky. The next topic I wanted to cover was potential explanations that you and Judge Watkins have for why we're losing people on the list. I know there's lots of theories and thoughts, but why do you all think this is happening? You're in the courtrooms and you're seeing this.
Well, I try to exit interview my people, so some of them I know retired during COVID. Pay issue is the number one thing cited to me is that they can find something else that pays better, that is not as emotionally taxing on them. I just said a few minutes ago is that we have, lawyers are now basically 100% child welfare specialists. So they typically represent families in multiple counties. So they unfortunately kind of go to the places that are closest to their homes or pay the most money. As we said, earlier, these are high acuity cases now. So with less filings from the Department of Family and Protective Services and more complex cases, they're harder to deal with. And I think the amount of secondary trauma that our attorneys experience is probably significantly higher now. they have less clients that, you know, I guess I'm not exactly sure what the statewide reunification rate is at this point, but I would say with lower filings and more serious cases, the reunification rate's probably going to start trending down, which if you're an attorney, you spend a year of your life helping a family, or we'll say 6 months to a year and a half, then you really want your cases to be successful. Who wants to go to court and, you know, have all their parents, you know, only half of them get their children back? That's not a great experience. Obviously, these are very high stakes cases. I think it'd be very hard, and I did this in private practice. You know, you're the person who's sitting next to your client when a jury or a court says your rights are terminated. That's traumatic for you, not just for your client. So I think these are hard cases and sometimes depressing.
It's compounded when they're not getting paid for it. So most of the folks on my wheel don't do this for the money. If they did, they wouldn't make a living, but they do need to be paid for what they do, and it varies. There's no statewide rate for the attorneys. It's up to each county to decide what they're going to pay. And often I'll be with Judge Stuckey and a lot of other judges, and we'll be asking, you know, what's your county paying per case or per hour on these cases, trying to keep it at least somewhere in an average, so that I'm not losing attorneys to neighboring counties that are paying more, or one of us is not outpricing the other, because he's right, we all use the same attorneys. The attorneys that I use in Brown County are the same ones that are used in the Hill Country, are the same ones that are used. In fact, I change my docket day so that I'm on this day, so the attorneys can appear in my court on this day, and they can appear in somebody else's court on another day. And we've promised to keep it that way so they can make it to all these courts. But then they have to bill the different counties, and then they have to wait on the county treasurer to pay them. I just had one of my best attorneys play chicken with my county treasurer, and it was the first time I'd been in the county treasurer's office, I'll tell you, because I went in and said, you can't hold him hostage anymore. You have to pay his bill. I signed it, pay it. And it took him coming off my wheel and me losing my wheels for him to get his bill paid. And that shouldn't happen. If they're putting in the time and the effort and they're putting in their bills, it should be a seamless process. But because it's so disjointed from every county I've ever been in, and I've been in quite a few, from East Texas to West Texas, it's always been disjointed like this. It's never been a set rate. It's never been a set way to turn in your billing. It's never been easy. As long as I've practiced, it's never been easy to turn in these bills and get paid for the hard work that you're doing.
Okay, we're gonna, of course, I knew we would run out of time, but I have some things that I want to make sure that we cover while we have everyone here and watching. So obviously we have some capacity issues that we need to deal with. This is a problem, and we have wonderful dedicated judges and people. We're falling apart, literally. Wonderful people willing to do this work, but we need to fix this system, because what we have right now is really probably not working. So we do have some potential solutions. It's not all gloom and doom, y'all. There is some hope. So Dylan, I would like for you to talk some about OPR, OCR. I know you've kind of explained how they work, but you had the luxury of being at OCR near the inception,
Sure,
right?
yes.
When you were a staff attorney. And so if you could kind of explain how it started, was funding and support helpful, like how did the office begin? Does it magically appear, or what's needed to start these?
That's a good question. It takes me way back in the Wayback Machine when I first started at the Office of Child Representation, when it was founded back in 2009, and it was actually founded by seed money from the Texas Children's Commission, which I worked at subsequently to joining OCR, and the idea was to try to, again, institutionalize and standardize representation of parents and children. So it gave that sort of that push along with some of the Travis County judges at that time to get the office started. And I think one of the things that was challenging at that time, it was the first time anybody in Texas had tried to create that office. And I remember, I think like you, I also got my start at the Children's Rights Clinic. And I will be totally honest, I stole a lot of things from the Children's Rights Clinic when we were first setting up our policies at the Office of Child Representation, because that was really the only standardized idea of how to practice as an attorney for children that we had. And so it was a real learning experience to try to figure out how do we do things, what is our capacity, what's a reasonable caseload for an attorney. And I think that's one thing about now the office is very well established, is I think we have a much better idea of that. And just to give you an example, when we talk about capacity, when I was an attorney on a private wheel, I think I had the ability to maybe take 20 to 25 cases was probably a high caseload. Our attorneys handle 40 to 50 cases, so roughly about double the attorneys. And with the support of social workers and staff, that's a manageable caseload for an attorney. I think the other thing that really drew me to the office, and I think that really helped, was the stability of it. As an attorney, I did not like the inconsistency of billing, and never knowing exactly when and how much I was going to get paid was a constant source of stress. So just having that stability of knowing that you were going to get that regular paycheck was a huge draw into, I think, me joining the office. And I think one of the other things about that is it helped create a supportive office culture. And what I mean by that is when you're in private practice, there's a lot of burden that you sort of carry on yourself. I remember thinking, it was so stressful to even try to take a vacation when you were just one attorney on a wheel, and be able to have other attorneys who can support you and cover you if you have a sick day, or if you have a vacation you want to go to, or you have your child's school event that's really important. The ability to do those things and yet still do the work and not have that be an overload on you, I think is really, really key. And then I think the other thing that I think really helped me and made me feel how much different the office was versus representing in private practice was having a social worker on board who understood trauma, both in the sense of what our children went through, but also in terms of what we were going through as attorneys, because I think you've all highlighted that like that. That secondary trauma is very, very real. You are dealing with very difficult circumstances on a day-to-day basis. For me, even as a managing attorney, just reading all the affidavits that come in it takes a toll on you. And even cases that settle can take a large emotional toll. I can think back, and probably one of the most emotionally exhausting things I did as an attorney in these cases was going over an affidavit of relinquishment with a parent. And that's a case that's settling. That's a case that is having a good, uncontroversial outcome. And I remember I would always just come away from those sessions completely emotionally drained, because it's really hard to sit with someone and go over a document where they're voluntarily giving up their rights is just an incredibly emotionally difficult thing. And that takes a toll on you as an attorney, not just on the parent who's doing that. So having a social worker who understood that trauma, who could help us understand what was happening to ourselves, and then creating a collaborative, supportive work culture, I think is the key in having long-term stability and being able to practice this work.
Yes, and so we only have one of them right now, so we need a little help. So we only have like 4 minutes, so we're going to go real quick. This is an important topic. And I'm just going to ask both of you judges a very pointed question. We've had these statutes on the books for a long time that we can build these offices, or we could build a manager-assigned counsel program. Do you think if you're, like right now, could your county just build one of these things without any kind of state support or assistance?
No, absolutely not. Way that, especially for far out, and what I would consider building capacity, building capacity is almost impossible to start something like that without outside funding. And just getting our public defender's office in there was amazing, and they're doing incredible things for that side of it. So in a rural county, I would say it's impossible to do it without some outside help. It's just not going to happen.
What about you, Judge Stuckey? Do you think we could just set one up in Caldwell County without some extra support?
No, I think it absolutely has to have seed money. No matter what the source is, we have to have seed money, whether it comes from the state or someone else. And other than the state, I'm not really sure who would provide that money.
And Judge Watkins, I know you have some thoughts on this, but what do you think attorneys should be getting paid for to do high-quality legal representation? Not just the, showing up as a body in court, but what do you need to see from lawyers to do good work?
I think it's pretty easy to see when one of your attorneys is invested in the case, to get invested in the outcome of the case, to know the case law. It has changed and exponentially since we first started doing it, right? Child welfare went from being something that was talked about maybe one day in your family law course to now something you can specialize in. So attorneys that do this and do this well are going on home visits. They're going to see school teachers. They're attending ARDs. They're talking to parents. They're talking to placements. They're talking to grandma. I have some that will travel from Concho Valley down to Houston. That's a 6-hour drive to visit their kids and come back. And what they need to get paid for is every minute of that time, because it's important to that kid and it's important to the outcome of the case. The better representation you have up front, the better outcome you have, the less time the whole family spends in the system. So if we pay our attorneys up front for all of the good work that they're doing up front, we're not going to have to pay for a child to be in the system until they're 18 or 21.
And do you think counties in general are able to statewide pay for all of those things that should be paid for?
No, and not only do I think that, I know that. There are some counties that can't afford to pay for attorneys to travel. Some that can't afford to pay for them to attend meetings at CPS. And good Lord, there are a lot of meetings at CPS. So they're not likely to go to those meetings. If they're not going to the meetings, they know less about the case. I mean, it's kind of all wrapped together. But down to the funding part of it, if the county can't afford to pay for them to go, and so they only get paid to appear in court, some attorneys will only appear in court. And then that's going to affect their kid in the case in the long term.
What about you, Judge Stuckey? Do you have any thoughts on how important it is for lawyers to get paid for the work they're doing?
Yeah, I mean, I think you pay for what you get. You can either pay for kids to be in substitute care, you can pay for the kids to be with relatives, or you can pay the attorneys to get them home. I think you just choose where you spend the money, and I think the best place to spend it is on our attorneys so we can reunify families and put them back together. That's what we are statutorily obligated to try to do first, so why not spend the money on the attorneys?
All right, and I know we're out of time, but I just want to give you all an opportunity to each of you have just final thoughts for the group about this topic. I know we all have thoughts, but I guess we'll give it to you, Dylan, and then we'll go to Judge Stuckey and Judge Watkins.
So one of the things that always strikes me when I look at the Texas statistics, which I did a lot at my old position at the Children's Commission, is that Texas actually does a really good job of not removing kids. We've always been low, and now we're even lower. But what we have never really done well and still don't do well is reunify families. Texas rate of reunification is roughly around 30%. That's well below the national average, which is about 50%, and some states get as high as 60 or 70. So we have a lot of room for improvement in reunifying families, and quality representation of parents and children is key for that, to make sure they have every chance to get their kids back, to make sure the kids have every chance to be with the parent that they know and love. I think every Texas family deserves that, and right now they're not getting it, and we can't do that without improving the quality representation, because as good as these judges are, as they mentioned, they can only make decisions based on the information that comes in front of them, and if the lawyers are not visiting their clients, they're not investigating their cases, then the judges aren't getting the full picture about what is happening with that family, and therefore they can't make the best decision regarding that family. So I think about that all the time, that every family deserves the best possible chance at remaining intact, and quality legal representation has been shown to do that, and I think that's where we are, the gap that we are missing in Texas.
What about you, Judge Stuckey?
I think Dylan did a good job. I think it's exactly what we need to be thinking about with these cases. It is about these families, and if you don't know the families and you don't know the kids, then you cannot represent them well.
I would say that I have seen good attorneys speak to their clients before even the adversary hearing and manage to get information from a parent or even a child that gets them out of the system completely. gets them with a relative or somebody they would never have thought of, and that they're not going to talk to the department about because they've just had a horrible experience with the department. I have seen good attorneys working on behalf of children who've been in the system for 3, 4, 5 years and getting them adopted by zealous advocacy. And that attorney can make the difference in that family and child's life for them personally, but also can make the difference in them being in state care for much longer than they would ever need to be. And it seems tragic to me that one thing can be the difference. We could really make a difference by just getting them some zealous advocates and getting advocates that are paid for being zealous.
I think that's a great place to end. Thank you, everybody. Thank you for your time. Thank you for listening. It's an important topic, and we hope that everyone keeps thinking about it and how we can support the work. Thank you. Anyone have questions? No questions.
Yeah, it's fine. Thanks to everyone for coming out today. Need to turn on the mic. Thanks for everyone for coming out today. Greatly appreciate you taking the time and learning about these important issues. I think as you heard from both panels, additional resources are greatly needed both for criminal indigent defense as well as family protection representation. As we've mentioned before, no state funds right now going to family protection representation. We have a number of models that TIDC could fund given the resources, and I think as you heard, the counties do not have the financial capacity to do so today. So I'm hoping that message comes through that with additional resources, improvements can come to representation, can help reunify families and ultimately reduce costs to the state and create families in a better situation. So thanks again. Once again, we will be sending out the recording, and hopefully for folks who could not make it today, they'll be able to see some of the highlights. So thank you all. Have a good day.